Very soon I will concentrate on motions. Because before vacation,
Absolutely right. We are on the last stage.
Maybe, sir. But before vacation, that too, this bench will not be available from 1st to 12th September circuit.
Automatically,
so I will give preference to motions. Let it appear on 2nd. Let us see. I can, this much I can tell you, if all the parties are not there, I will not take up. If adjournment is straightforward, I will definitely consider.
My lord, may I be permitted to mention urgent motion, my lord, of the Honorable Justice Bhattacharya, that yesterday your lordship granted me the
you have got the number
and file is lying your lordship's court.
ঠিক আছে, তাহলে এটা দিয়ে দিন।
And I already served the notice.
Tuesday,
my lord. Today is Tuesday.
Oh, today. Sorry.
Wednesday, my lord. Tomorrow is the same similar matter fixed, my lord, subject to correction, my lord.
আজকে কত তারিখ? আজকে 29।
29.
Well, where is your other side?
I have served notice, Dr. Patra.
Come tomorrow.
Lordship,
Motion top.
Already matters were fixed yesterday.
Huh?
3 matters were fixed yesterday. This will appear with
Come
those
tomorrow.
matters.
Your lordship
It
fixed
shall appear under the heading motion top tomorrow.
Yes. Great.
My lord's kind leave to file this matter and move this urgently, my lord. This matter, my lord, I am a Group
And you
C.
bring whatever law and rules you want to cite.
Yes.
My lord, I am
You also bring the judgments and all, whatever.
My lord, I am a Group C employee. Recently, I have been handed over with a notice saying that an overpayment of 17.5 lakhs has been made to me for a period of over 15 years. My lord, I am a Group C employee. That deduction, my lord, they have.
Rafiq Mashi,
Yes, my lord. My lord kindly grants me leave to move this
when
matter.
you are retiring?
My lord, I am retiring in 2019, but each month they are deducting. 2029. But each month they have already started deducting 34,000 from my salary. They have already deducted one amount. I have made a representation.
First you obtain number, then mention. There is no urgency.
My lord, the only hardship why I am saying this, my mother is a cancer patient and she's undergoing chemotherapy. I'm short of funds, my lord.
First you get the number, then you mention.
I'm so grateful.
It's not that urgent. Yes. Why to be mentioned?
My lord, it was mentioned yesterday. There was a mistake in the presentation form. Not mistake, it was at that point determination was the library science was under the Group 2.
So it's a Group 2 matter.
It's a Group 2 matter. But it was written Group 6. That present liberty may be given to correct.
At the instance of the petitioner. Upon the matter being mentioned by Mr. HON'BLE learned advocate, comma, the writ petition appears today under the heading to be mentioned. Full stop. Paragraph. None appears for the respondents. Paragraph. On the prayer of Mr. Bari, leave is granted to correct the presentation form by putting the correct classification list. Since this writ petition pertains to Group 2 bold, Group Roman 2 of the bold of the classification list. Full stop. The writ petition after the full stop. After proper correction being carried out, the writ petition shall appear before the appropriate bench, subject to its convenience. Yes. Yes.
I mentioned the matter, it is relating to determination of Justice Bhattacharya. What has happened, my lord? During the
একবার ফার্স্ট প্যারাগ্রাফটা লিখে নিন, ভুলে যাবো পরে। Upon urgency being pleaded, the matter was mentioned, comma, since the regular determination has been assigned before this court, comma, the writ petition has been taken up for consideration upon publishing in the daily cause list. ঠিক আছে।
Yeah, it was moved earlier. The court directed to file and report by the service commissions. Report has not been filed. Anyhow, during the pendency of the writ applications, my lord, what happened, my lord, 2 days back, my lord, they have published notifications for holding counseling on 1st. That
Where is your application to that effect?
no, not applications. The supplementary affidavit is there. Your lordship, my lord, I have said so. The not there down a supplementary affidavit down. Notice তো কেন তো এ তো আছে নোটিফিকেশনটা দাও করেছি দাও নোটিফিকেশন দেখাও
You should have come up with an application with that
Not application, my
document.
lord. This is because of the fact the court was of the view when it was moved that the counseling is not there. That's why it was directed to file a
Today you are,
liberty was given to move before your lordship, my lord, to move at the time. Your lordship kind down না অর্ডারটা দাও না কপিটা যে অর্ডারটা হয়েছিল রায়চট্টগ্রামে
where is that liberty, sir?
yes my lord, your lordship
Kindly
can-
see the order dated 14th May.
I'm on that.
Liberty was given to move the regular bench
Yes.
after the
because at that time there was no counseling.
According to the petitioner, they are bona fide absentees in the rounds of counseling. By filing their respective representation before the chairman, West Bengal Central Civil Service Commission, they have sought for further opportunity in counseling. Dr. Patra has raised objection that an absentee candidate in the counseling process is not entitled to any further opportunity in terms of the rules prescribed.
after this order dated,
Now,
One minute. That's the only order.
yes.
this is
The
all-
report has come.
No, the report is not ready,
Acha.
but it was
Now-
made returnable 2 weeks after the vacation. In the meantime, there was one round of counseling on 11th June. I don't know why the petitioners sat tight over it. So for that date also, they were not interested. Now in the 8th phase counseling, they are coming to intervene in spite of the fact in the order it is recorded that they were bona fide absentees, meaning they were called
that
and
is the
they
merit. That I
chose
saw.
remain to be absent.
Now your lordship.
And the rule does not allow absentee candidates.
Sir, I cannot take up like this.
No. I am only drawing attention. The date of counseling is fixed on 1st.
I will record your oral submission.
Extremely careful. Now your lordship kindly come to the main. Order. And my lord, leave may be given to the supplementary. I have served the copy upon the other side.
Ashun, on the prayer of Mr. Bari, learned counsel for the petitioner, leave is granted to file the supplementary affidavit. What is this?
One of the supplementary affidavit annexing the rank number and the
Disclosing the rank of the petitioners,
and category.
disclosing the rank of the petitioners in their respective categories. Show me who are the petitioners from rank,
My lord,
serial number.
all. My lord, I have given the all name. Your lordship.
These 20 are the petitioners.
Yes, these 20 are the petitioners.
You have paid all 20 court
All
fees.
court fees.
Very well.
Yes.
Yes.
Now, what has happened, my lord? These are the petitioners who are the successful candidates and they were impaneled for counseling. My lord, what has happened in 2016 process? We were the teachers. We are the teachers, still we are continuing. Are the teachers of my lord 9, 10, 11, 12. Now, my lord, your lordship knows that the entire selection process was have been directed to be cancelled by the order of the.
But those are not material. As you have submitted, Mr. Bari,
Yes.
that for whatever reason, these 20 were absent when the Viva Voce was
Right,
held.
right, right.
Whether
Not
those,
proposing. For the purpose of counseling.
whatever, part of the selection process,
Right.
counseling was held.
But
Whether-
counseling,
One second. Whether they are entitled to,
Appear in
Participate.
the.
that's right.
This is
So
the-
make that submission.
this is
the
the
counseling is only the choosing of the school,
choosing of the school.
of the school. They are selected, all candidates who are selected.
All they will get the job.
Yes,
Yes.
on the on the basis of their rank, they will be called for counseling. There is the main panel and the waiting list. So
Suppose they chose not to appear.
yes,
Then what will happen?
then they will be marked as absent, and as per the rule, the absent candidate will not get a second chance. That is the rule.
Second chance for
Coming back
counseling,
for
counseling.
counseling subsequently.
counseling.
Yes,
But their appointment will be made then how?
they will not be appointed. They were absent. They did not participate.
Acha, he did not participate in the examination process.
The examination they have done. After the examination, they have gone into the merit list, meaning the panel and waiting list. Now we are only to give them an opportunity to choose the schools. So the pool of school is shown to them as per their rank, one by one, they pick up a school. And this
Oh, so if they don't attend counseling, the
leftover schools
leftover schools will be distributed.
to the waiting list in the next phase, again leftover in the next phase. In that process, now we have reached the 8th phase, which is to be held day after tomorrow.
And they were called in which phase?
My lord, there's a multiple candidates. Some of them were called in the very first phase,
First phase.
if not all. So that was in November 2024.
Only the reason we have submitted, the reason is that matter was pending before the Supreme Court.
So who barred you?
Yes, madam.
All right, but
No, because of the fact, madam, this, as the matter was pending before
no,
the.
no, you show me that there was a restriction imposed on these 20
This
candidates.
aspect of the matter was considered by the coordinate bench. It is just a- And submission which was made by Mr. Dr. Patru, it was taken into consideration and court passed an order. ওই, মুক্তি বিশ্বাস। Exactly, my lord, the case of the petition is here.
Any appeal preferred from this?
No, no appeal.
No appeal.
No.
So you have acted upon this order.
Yes.
My lord, this order was.
Acha, you read on then.
Let me just check it. It is.
No, no, you read on. Let me also read.
This was an interim order.
Yes, yes. I was sitting in interim order. Final to চাইছি না। Supplementary Affidavit. Untended note. এক্ষুনি দিয়ে পাঠিয়ে দিন বলতে হবে। ওটা পাঠিয়ে দিতে হবে 17 নম্বর আপনি কাটতে গেছেন। রানার বানার সময় চলে না তাতে চন্দ্র বসে আছে।
Yes,
This is exactly, my lord, what submission was made.
so you are allowed to continue till 31st December, all of you.
All of us. Well, the only participation while it has been submitted exactly, my lord, the no change, same case, and the counseling is scheduled to be held day after tomorrow. This is the my
All right, let me hear him, then I will have few
Yes,
questions to you.
yes.
My lord, factually, this is more or less the same. I am not disputing that. There is no appeal also. Here, there was only one candidate. The direction was given, and we have complied with it as an interim order because it is subject to the result of the writ petition. Here, there are 20 petitioners. 8th phase counseling has already been notified, which would mean that we have already identified the vacancies, I think 48 vacancies, and we have already called equal number of candidates to participate in the counseling on the first, on Friday, that is 1st August, which would mean that all the vacancies will be exhausted. If these candidates are allowed to now enter, there will
There will be 48 posts, 68 candidates.
Yes, and those who will be coming day after tomorrow with the expectation of choosing a school, they might be knocked out from the zone. Now, why I am opposing these candidates is firstly, the writ petition, they have come jointly in one writ petition. All documents of all candidates are not here. As far as their intimation letters are concerned, for the call which was given for them in the first phase counseling, some have given their intimation letters. That is acceptable. Some have given their intimation for personality test. That is not acceptable. Some have just shown their rank position in the panel, which means that possibly their turn might not have yet come. In addition to that, the rule is very specific that an absentee candidate,
Show me the rule.
I'm handing it up, but before that, just one last submission. The petitioner, the order upon which they are relying, they are all similarly situated. They all lost their jobs on 3rd of April 2025. These candidates approached the court for participating in the 7th phase counseling. It is recorded in the order which was held on 11th June 2025. Where were these 20 candidates on that day? Their writ petition was already filed. Their order was already in their favor that the report is to be filed. That order was dated 14th of May. 11th of June, so they will just come strolling along whenever it is convenient for them and say that we want to participate in a counseling and deprive other candidates who are equally eligible. Now, just kindly see the rule. This is the upper primary rule. Schedule 5, Clause 8. Very small provision, one line, that an absentee candidate will not be given a chance. This was also pointed out in the other matter also. It is, but
No, but that has not been dealt with.
no. Once absent, the vacancy will go to the next candidate. And
Yes, then
this is all. And my main submission is this, that if they were really very eager to join as upper primary teachers, firstly, there is the fact that they have lost jobs is not an excuse for not participating. They could have come and participated in the first phase counseling. Their recommendation would have been valid for 90 days. They could have waited to see the fate of but they should not have presumed that they will get a favorable order in Supreme Court. We always say that you should keep the worst in mind. Hope for the best, but be prepared for the worst. So they sat tight during the 7th phase counseling. Now suddenly they have woken up and they say that we want to disrupt. The panel is valid till 25th of September. So there is no real urgency also. Even if the court does not pass any order today, I still have vacancies. I still have waitlisted candidates. My counselings will continue.
no, but that's not the issue. It কি হচ্ছে? কি print out নিচ্ছে? The thing is, what you are saying that the counseling will be on till, let's say, 25th September.
Not continuously. When the 8th phase is over, then as long as the panel is alive and as long as I have vacancies.
Vacancy vis-a-vis wait list.
Yes.
Now, the moment one chooses not to appear, Mr. Bari, knowingly he has waived his right. Knowingly he has waived his right not to appear. So automatically, let's say the petitioner ranks is 5. The moment he does not appear, automatically a right to participate is created in favor of 6, 7, 8, 9, 10. I'm not saying right for selection.
Very good.
Right to participate is created 6, 7, 8, 9, 10. Now, the moment he will be intrude as a 5th rank candidate, they will lose their turn. So will it not amount to an encroachment of subsequent candidates' place at the whims and will?
My reply will be submission. Exactly, Dr. Patro has taken point before the coordinate bench. Then, my lord, I remember the observation of the court, who is responsible for entire selection cancellation of these candidates who have rightfully appointed, and they know that
No,
they will lose the job.
might
It is for
be,
the problem was created by the School Service Commission itself.
might be, but what
Whatever.
will happen?
Now
to
I'm
the-
coming one after another.
No,
One after
that,
another.
no, I will hear you, sir. I
Yes.
will hear you one after another. Apropos this, first, there was no restriction imposed on these candidates to participate.
No, I have said so, and court was taken into consideration.
They chose not to,
Yes.
whatever reason. They chose not to, for whatever reason. I'm not on that. The logic you are giving may be appealing. Kindly visualize the logic for the subsequent placed candidates who are after these candidates.
Well, the question is, if I illegally terminated, as per service law, if I am illegally terminated, well, what will be the consequence? I will get my job
No.
with all consequential relief. That is not here. The peculiar situation was there.
No, then what will you tell me? What will happen to those candidates?
No, that candidate, my lord, they share mayor, they right. It is not your lordship giving no direction to give appointment. The matter will be taken into
No,
considerations.
Sir,
Today, your lordship
sir,
considered.
sir. What he is saying, let us take an example.
Dealt with by the court.
Yes.
Your lordship kindly let me, my lord, place this order.
Dealt with is from the sentence in view of the aforesaid.
Yes.
Before that, all the submissions
Yes,
are recorded.
yes. Dr. Patro, page 3.
Hmm.
Dr. Patro, learned advocate representing the commission, has opposed the prayer of the petitioner to allow her to participate in the ensuing collection process in connection with the first state level selection test 2016, since the petitioner, in spite of being permitted to participate in the previous round of the council, did not turn up. Exactly that submission was made. It is also submitted at this stage. If the petitioner is permitted to participate in the counseling, if she comes within the zone of consideration, that would make the entire process topsy-turvy. Exactly that submission. It is submitted that a stand has been taken on behalf of the commission that absentee candidates are not to be permitted to participate in the ensuing council process, which is scheduled to be held 11 June 2025. 3 phases of submission was taken into consideration. Now, another learned judge dealt with another leap of submission on behalf of the commission. If it is permitted to participate in the ensuing counseling, a candidate who has already been chosen for counseling would be ousted. Exactly what the query of the court.
This is really troubling me.
Yes. First, before considering the issue raised in this petition, this court needs to find out whether the petition is intended candidates or not in connection with the selection process, since in terms of the judgment, the Honorable Court stated certain tainted candidates have no right to offer their candidature in fresh election. We are, my lord, the intended candidate that we have categorically mentioned. In this regard, it is submitted on behalf of the petitioner that she has been permitted to continue as an assistant teacher till 31st December 2025, which goes to show that till date the petitioner has not been identified as stated candidate in connection with the first instance. Exactly, we have been allowed to continue up to 31st December. This court needs to consider the issue in view of the special circumstances where the petitioner has lost job since the entire selection process first is 2016 for 9 and 10 and 11 and 12 has been certified by the Honorable Supreme Court to provide judgment dated 3rd April 2020. It needs to be taken into considerations that petitioner also participated first SLST 2016 for upper primary level of classes, and where she was selected but she did not participate in the previous round of the counseling, since at the material point of time petitioner was working as assistant teacher high secondary schools on being selected in the selection process. Exactly, my lord, this is I am trying to make submissions. The why I have not. My lord, the court said since the material point of time petitioner was working as assistant teacher in the higher secondary section on
In all these 20
All,
were
all,
asking.
all,
Very
all,
well, I
all,
admit.
all.
Then
subsequently petitioner has lost job after said selection has been declared illegal, which triggered the present petition, and prayer is made to permit her to participate in the ensuing counseling process, which is scheduled on 11th June 2020.
now you show me how these points are dealt with.
Not it is the interim order. It has not been the finally. It is the why the court is passing this order. Only observation. The court matter was kept pending.
No,
It is not the
these were the
in view-
submissions.
your lordship can- then it is the observation of the court. Then it is not the submission. It is the court's
No,
observation.
in view of the
In
aforesaid.
view of the aforesaid scenario, concerned authority of the West Bengal Central School Service Commission is directed to permit the petitioner to participate of the counseling schedule to be held on such and such. If the petitioner comes within zone of consideration in terms of her merit position in the list, if the petitioner is not tainted candidate. But the concerned authority of the commission at the time of self-verify the credential of the petitioners. Let them verify that Dr. Patra was, whether they are, well, they will check up all this issue. This matter on the heading mentions 14 July, when the concerned authority of the commission shall file a report.
No, that's not
of
neither.
affidavit disclosing the
You
result.
just satisfy me on this
Yes.
first.
Well, this is the my humble submission.
Kindly
of
come to page. Kindly come to page 4, top,
Yes,
first paragraph, page 4.
page 4, first paragraph. Another limb of submission.
Yes.
Another limb of submission made on behalf of the commission is if the petitioner is permitted to participate in the ensuing counseling, a candidate who has already been chosen for the counseling would be ousted. First, before considering the issue,
No, not required. Not required.
then
This
my-
paragraph.
then, my lord, your lordship, kindly this court, page 4, bottom portions. This court needs to consider the issue in view of the special facts and circumstances where the petitioner has crossed job since the entire selection process has been set aside by the honorable fight judgment dated. It needs to be taken into consideration. The petitioner also participated in the first selection 2000 for upper primary level test, where she was selected but did not participate in the previous round of counseling. Since at the material point of time, petitioner was working as assistant teacher in higher secondary selection, being state level selection date for class 11 and 12.
No,
So,
so
this is the observation of the court. The court will consider finally, after they file a report, the matter was kept pending, matter was
you
directed.
just give me this answer first. This first, I must, you clear my mind
Yes.
on this.
Your lordship kindly.
Suppose what he's saying, suppose
Madam-
there are 48 vacancies.
That today your lordship is considering whether they will be permitted on council. This court did not say that you appoint tomorrow. You appoint. Court
Automatic,
has,
sir, acha, sir, very well.
court has fixed the
Very
matter.
well, very well. They will participate. This lady will participate.
Participate and they will have the outcome, the result.
Now, let's say after this, the rank of this petitioner,
Yes. Yes.
there are 50 more.
Mala, all will be, the question is, the court will consider the entire, it is not that one case, the court will consider the issue as a whole. If I am, the point which has been raised by the court, if it is not, it is not fit to the court will pass an order. Court simply, as an interim order. Your lordship, day before yesterday, I moved a matter. Whether the age relaxation can be done. Your lordship, remember? In view of the larger judgment, your lordship permitted, subject to the result of that. So today, what your lordship is considering? Whether the particular date on Friday, it will only one day, it will be taken into consideration.
In between, one counseling has been held.
Yes, madam.
In between this 7th counseling, this 11th June counseling has
Yes,
been
it
held.
was mentioned before the court said when the next round of counseling, because
That is neither here
that
nor
is
there.
another question.
That's
Today,
neither
madam,
here
on the
nor there.
Friday is the date for 7th round counseling. So, madam, today your lordship is considering whether they will be permitted to appear.
Secondly, you come to the rule.
Madam, they cannot say that the one order I have complied with, other order will not. The principle laid down. You have to, madam, you cannot.
No. They don't say that. They say that its appeal has not been carried out. They say,
They have accepted.
but it is a coordinate view. I can also give my view. So there is no difficulty. You kindly also come to the rule 8. Absentee candidate shall not be called for any
Madam,
second
this is the
counseling.
absentee candidate not voluntarily. It has been recorded in the court. The matter was pending before the Supreme Court.
So-
We lost the job.
So-
Your lordship kindly.
No, but there was
Yes,
no
sir.
restriction imposed on you.
No, my lord, your lordship kindly see this aspect of the matter was considered by the court. Your lordship kindly. Dr. Patrul, an advocate defending the commission has opposed the prayer of the petitioner to allow her to participate in the counseling in connection with the scenes in spite of being permitted to the previous round did not turn up. This is the question Dr. Patro raised before the court. He did not turn up, he will not give the chance. The court said it is also submitted that if the petitioner is permitted to participate in the counseling, if she comes within zone of consideration, that would make the entire process stop with us. But it has been submitted.
No,
but
that's all right, but there is the.
now
no-
the court, it is submitted, the stand has been taken by the commission that absentee candidates are not to be permitted to participate in the ensuing council process which is scheduled to be held. Although the rule was not quoted, but the absentee candidate will
No, but
not
the
be
rule is staring at me.
permitted. That is your lordship considering today interim order. Your lordship is
If
not
if I pass an interim order, Mr.
Malad,
Bari,
relying
it
today-
will it not be in glaring violation of Rule 8?
Malad, this was taken into consideration, not mentioning there is a gallons of the judgment, not mentioning of the sections. Malad, it cannot vitiate the entire process. It has been, Dr. Patru, your lordship kindly see. The absentee candidates are not.
Yes, I accept,
Yes,
I accept, sir.
yes.
I accept exactly same facts or situation.
Yes.
I accept.
And my lord, why they are doing this under the pressure of the appeal court? Appeal court said, whatever selections you made, what they are coming into consideration, total post, I'm giving you lots of details, you should fill up that post. My lord, this appeal, I have got this copy just, it is just with them.
They're not required, sir. These are not before
It
me.
is required, it is required. For adjudication of this matter, it is required. Your lordship kindly, it is required for adjudication of that. Your lordship kindly takes trouble. I'm not wasting your lordship's
No,
time.
not at all, not at
By
all.
your lordship, for adjudication, it is required. Page 45, para 37, if your lordship kindly.
You're welcome, sir. You're most
No,
welcome to make your
Your
submissions.
lordship considering today it is not the final judgment or full-fledged hearing.
No,
Your
no,
lordship
of course.
considering the interim
Of
order,
course, of
which
course.
is required.
No, sir. Absolutely, you are welcome. You should
Mala,
make
this,
your complete
Mala,
submission.
why I was showing this judgment.
Paragraph, paragraph.
I'm coming. In terms of this order, under the pressure of the court, they are holding the counseling. I believe Dr. Patru will not deny that.
Very well.
No, I will deny.
Let that be. Let that
No,
be.
definitely deny
let
it.
him deny.
There is no pressure.
Paragraph.
Your lordship can be. Thirty-nine.
13.
39, 39, page 46. Upon such re-evaluation initially 1463 for mismatch of the class category 559 for mismatch of the marks and defaced OMRC were excluded. Upon further revision and perusal of the records of 902 candidates, 752 candidates were brought within the zone of consideration. Accordingly, 1463 minus 750, 7130 were ultimately excluded. Such exclusion is not substantial law, and consequently, the said candidate also come within the zone of consideration. As there are in total 14,339 vacancies, very important. As there are total 14,339 vacancies, there cannot be any hindrance towards inclusion of all the candidates called for PT being for 14,052 candidates in the merit list as against 14,339 vacancies. In our opinion, the Commission had no jurisdiction to reevaluate or recheck or scrutinize various aspects of each of the aforesaid 14,052 candidates by an independent agency after the completion of the PT. Such act is thus not sustainable in law, etc. Accordingly, this court directs the Commission to prepare and publish final merit list and the panel in terms of 12.2 and 12.6 of the respectively of the 14,052 candidates in accordance with law within a period of 4 weeks. Within a period of 4 weeks thereafter, the Commission shall hold counseling and recommend all 14,052 candidates who appeared in the PT. Upon such recommendation, the appointment letters shall be issued in the said candidate by the competent authority within. We are coming within 14,052.
Correct. But you chose not to appear.
No, personally test. Up to the personality test, we appeared. Not counseling, we did not participate. Personality test, we appeared. We have been selected.
Right.
If we appear personality test, 14,052 candidates are directed, have been directed by the appeal court upon the commissions to call everybody. So
Now,
show vacancy 14,052.
so you say in a way that there is no requirement for counseling. You just call
No,
14,000.
counseling is the option. Counseling for choice
Right.
of the school.
So anyone can.
I was successful in written. I was successful in a
No
personality
doubt, no
test.
doubt, no doubt.
Now, my lord, the total vacancy of your query of the court was that if I selected whether the other candidates question of other candidates accommodation doesn't arise because total vacancy is 14,052.
Correct.
We are coming within the 14,052.
Right. Even now out of this 14,000, let's say 400 opts not to appear for counseling.
No.
Like your case,
Yes.
400.
That will be vacant. That cannot be filled up by other.
So 400 will not be
No.
appear,
That
Correct.
will be the next counseling.
right?
Next counseling.
So
and next selection.
1,000 candidates appeared in the counseling. 1,000 candidates will be placed according to their merit list and the result of counseling,
Yes.
right? So 400 remain vacant. 400 will remain vacant
Vacant.
because
And-
those 400 and there was no candidate found in counseling for those 400.
No. That will I differ. Because the candidate was found, candidate chosen not to appear.
That's right.
No, so the vacancies is remain till the next selection process.
Correct.
Next selection process.
Correct forward.
Carry forward.
Yes.
So show till today the vacancies are there. So see if the vacancies are there, the submission of Dr. Patro, if they are filled up, other will be ousted from the zone of that is not the correct.
Then,
Because
why not?
14,000
You just make my mind clear on that.
14,50200 are directed to be filled up.
Right.
Today, my lord, the 400 chosen not to appear. Then, my lord, what will happen? That will be the carry forward next selection process.
Absolutely.
Now, in the peculiar circumstances,
What is
when the-
peculiarity?
because court said so. Court said
Maybe,
so.
but I don't find any peculiarity.
Because the peculiarity is this: our service have been terminated by the Supreme Court.
But
we are not
it's on adjudication.
No, we are not the tainted candidate.
Sir, I cannot go for that because that is an adjudication of the Supreme Court. Whatever reason,
Let
whatever
me say-
has happened, has happened.
My submission before your lordship should be, my lord, today your lordship is considering prima facie case which I have been made out or not.
That's precisely I don't find.
That's why, my lord, we have been selected. We were absentee candidate in view of the fact that our service was pending before the Supreme Court. And that was recorded that I have said so, only this is the reason. Court considered this reason. And
But there was no restrictions imposed on you by
the
Supreme
court
Court.
considered this aspect of the matter. And similar view was taken. If your lordship differ, no problem.
That's a difference.
But this is today your lordship is considering due to extreme urgency of the matter. What has happened? My lord, the Friday is the date.
I don't mind for that, sir. I will take up. I will give my reason.
Yes.
Whatever way I will
Yes,
decide,
yes,
I will give my reason.
That's why.
And I try to be convinced. I try to be convinced.
And my lord, my humble submission,
Please convince me. Yes, try to.
although my lord, it is a nature of the interim order, but I will be humbly praying before the lordships that is some bindings effect upon the court and bench also. Although it is not a judgment.
No,
Yeah.
tell me one thing. What is really troubling me, Mr. Bari? Clear my mind.
No, my lord, that is our duty is to assist the court.
Absolutely. Two things are troubling me.
Right.
First, on 11th June, on the first day on your due date, you chose not to appear. Whatever reason, I'm not going
Yes,
into the reason. Fact remains you did not appear. You got another opportunity on 11th June. You did not appear. You did not even come to court. Then look here, for whatever reason, I did not appear. Now you allow me to appear. You did not, your client did not do that. You allowed that counseling to be over. So let's say another 40, 50 or 100 candidates participated, whatever, maybe 5 candidates.
Right.
Now at each stage, they are being assessed. They are being assessed. Now, suddenly petitioners come and thought that no, now I will appear. Whatever will happen, happen. What has happened, happened. Please, I will appear. He is permitted to appear. Let's say his rank is 15th. He stood so well. He ranked so well. But the moment he has not appeared in the counseling when it was due for him, under the selection rules read with Rule 8, he has lost its right. He has lost its right to be in the for consideration for the selection process. So automatically the next candidate, he comes within the zone of consideration.
That is, I differ. That I am trying to submit before your lordships. The total vacancy or total posts are required to be filled up.
14,000.
By the order of the appeal court, 14,052. To show other candidates only that has been confined, 14,052. If the absentee candidates, the post will not be filled up, the candidate, it will be, my lord, the carry forward, next election process. Now here, my lord, your lordship is correct that why you have, it is not my willful, this is not the case that I have chosen not to appear one fine morning, I have thought that I will appear. This is not the case here. I have categorically mentioned the peculiar facts and circumstances. The court also considered this aspect of the matter. That
No, I don't find any peculiar circumstance.
court has recorded that.
Maybe, but I don't find because I
Because
tell
of the
you why.
fact, what is the peculiarity? Peculiarity is, my lord, their service have been terminated in view of the wrong committed by the School Service Commission. It is not.
Whatever.
It is not. But
Yes.
it's a vital issue.
Yes.
You, the better opportunity was 9, 10, and 11, 12. Now, it is the upper primary. To show upper primary up to class 8. Nobody will be willing to serve the primary level when I am getting the higher education or higher. So 9, 10, 11, 12, we have been given opportunity and we have been selected. We are rendering their
Then,
services.
Mr. Bari, the candidates should have been more vigilant that our selection process is already under challenge. Since I am
No, subsequently, it is not. When I got the appointment, it was not challenged.
no, this counseling tenure.
Yes.
The day you were called for counseling, then it was under challenge. Has to be.
Yes,
Has
yes,
to be.
Yes, yes.
So then the petitioner should have been more vigilant that since there is no restriction on me, I must appear. I have got a call, I must appear.
No, but
As there is no restriction on me.
no, restriction was there.
No.
Restriction was there. But at the same time,
What restriction, sir?
restriction was there.
Show me the order of court.
Well, and I tell you, lordships, when Dr. Patro will, the rule says that you cannot appear two at a time. Restriction for the upper primary and the upper primary and the 19, 11, 12, we cannot appear.
Whatever statutory rule is there, there.
Yeah, but by virtue of the court's order, they have been permitted to allow it in several cases, and the School Service Commission allowed that. To show there was a restriction, it is not the fact there was no restriction was initially there. However, today, my lord, your lordships, when they have the coordinate bench passed an order, dealing with all this matter, keep the matter pending for final adjudications. My humble submission would be your
No, the
lordship,
repetition will be pending.
yes.
But I am really not satisfied to allow him for counseling.
Because of the fact, if the counseling, if it is not allowed, then my entire repetition will be infectious. Because of the fact, it may not be the further counseling. It is extreme urgency. That's why I mentioned the matter.
Sir,
And if your lordships defer this interim order or defer this matter, your lordships can pass necessary order, no problem.
no,
But
of
my,
course I will.
yes, my
will.
submission will be before your lordships. It is the sum binding effect upon your lordships, and the whatever submission was made by Dr. Patro and the query of the court, everything has been replied.
No, but the distinguishing fact is first
No,
distinguishing.
not distinguished.
Of course.
Same. Because
The 11th June counseling, when this order was passed,
yes.
these petitioners chose not to apply before the court.
No,
They allowed that to
yes,
go.
before that,
They were already
Before
before
that,
the court,
Dr.
but they did
Patro
not
said-
move their matter.
before
They did
that,
not
Dr.
mention on
Patro said,
movement.
Dr. Patro said, no interim order is required. We are filing a report. We will get the chance in the next counseling. to show.
Next
court-
counseling was
court-
seventh phase
and
counseling.
Court did not, in spite of direction, they have not filed any report.
That does
What
not
is their
change the
stand?
fact that you sat tight during
Whatever,
the
whatever.
seventh phase.
But a setting tight over the matter cannot divert the petition from appearing in the interview, which is scheduled to be held. In the midnight, you have published the notifications. And that notification will have prompted to disturb your lordships. That the
So I was really troubled on that fact issue. That admittedly those 14,000 and odd are permitted.
yes,
No
and
doubt.
we have been included that.
You are included.
Yes.
Fine. But you chose not to participate.
And again, my lord, I am repeating my own submissions. Your lordships kindly have a look to this. Again, my lord, this aspect of the matter considered by the court and bench.
No, I've seen that. It was called, fact situation is identical. I accept.
Identical.
I accept.
If the identical fact situation is there, if the court considered this issue, my humble submission would be before your lordships, your lordships kindly accept that. Because it is not the final, your lordship not rejecting to issue the appointment letter tomorrow.
No, no,
That will be
counseling
taken.
means recommendation will be issued. Counseling
Then
means
you hold
recommendation.
the recommendation. You allow me hold the
Oh, so
recommendation
the
till the
school
matter
will
is
suffer,
that
the
school will
eligible
suffer.
candidate
5
will
years, the school
suffer.
did not suffer. The 5 years, the school did not suffer. This school will suffer for 5 days.
Yes,
Fantastic
it will not
argument.
be resolved in 5 days.
Yes, yes. 14th July, the matter was directed to be taken up for considerations. It is due to non-sitting of the court, matter could not be finally decided.
And in all probability, all these candidates will be participating in the second SLST and leaving these jobs and running away. And
That is the sir conjecture and surmises. You
no,
cannot.
not a conjecture. Let my learned friends say whether they have filled up the forms for the second SLST. They want to be everywhere, one teacher in 10 schools.
Your lordships kindly have.
Let them say.
So far the judgment is concerned, so that the coordinate bench judgment, although it is not a judgment, but my lord, there are some.
No, it is an interim order.
I have distinguished and I will further explain.
We will always go on distinguished, no problem. The court is here, court will accept. The rule of judicial discipline and propriety, the doctrine of precedents has a merit of prompting certainty and consistency of the judicial decision, providing assurance to individual as to the consequence of their action. The constitutional bench of this court have time and again reiterated the rules emerging from judicial discipline. Accordingly, when a decision of the coordinate bench of the same high court is brought to the notice of the bench, it is to be respected and is binding, subject to the right of the bench of such so equal quorum to take a different view and refer the question to the Lords of the It is only the course of action open to the bench to equal extent.
No, that's a final decision. That was a final judgment.
Yes, that I have said so.
Huh. That is it.
And my lord, there is not a slightest difference. There is
The
a,
difference is there.
no,
That
the
11th June,
factual aspect. No, 11th June, that was the counseling. That 11th June was over. It cannot be my lord, the second counseling on tomorrow to show why I have not.
suppose this petitioner who has been allowed, she has participated in the counseling,
Yes.
right? Now you tell me what is your submission on that 14,000 and odd?
Yes,
issue.
that I would like to submit. What did the court say? That was an observation of the court,
Division
that,
bench.
of the division bench, that you have.
That of course binding on me.
Yes, yes. That and with regard to this selection process. The court observed, it was not part of the directions of the court. The
No,
court,
of course direction.
the court observed.
Of course direction. Kindly come to 41.
May I read?
Kindly come to 41,
40, let us start from 40.
paragraph 41 first.
Accordingly, the court directs to prepare and publish the final
Directs the commission to prepare.
and panel in terms of Rule 12.5 and Rule 12.6 of the 2016 rules respectively of the 14,052 candidates in accordance with law within a period of 4 weeks from date.
Clear direction.
Yes. So we have done it.
It's a mandate.
Yes, it is a mandate. The preparing of panel and waiting list, not counseling. Not counseling.
No.
Preparation of panel and waiting list. Within a period of 4 weeks thereafter, the commission shall hold counseling and recommend all 14,052 candidates who appeared in the personality test. Upon such recommendation, the appointment letter shall be issued to the said candidates by the competent authority within a period of 4 weeks thereafter in accordance with law. This is to be carried out in terms of the rules which I have handed up. Now, after preparation of panel and the waiting list, what is to be done? Candidates are to be called for counseling. Nowhere does this division bench say that I will violate the rule. The rule requires that you will come and participate in the counseling and choose a school. We have called you, but you sat tight at home. Now, suddenly one fine day, you were a candidate of first phase counseling. After 7 more phases of counseling, you turn up. The court did not say that. The court did not say you will disrupt the procedure laid down in the rules. Anybody will just walk into any phase of counseling and participate. I am to follow the rule. So the panel waiting list prepared, admittedly. Candidates included, admittedly. Now comes counseling. Called for counseling, admittedly. Called in November. You lost your jobs in
April.
3rd April 2025. In between that period also, there were 3 phases of counseling. You were confident you will win in the Supreme Court. Very well. I have no comment with regard to that. Then you lost your job in April. In May, there was a counseling. In June, which is referred to, there was a counseling. And now again, there is a counseling, the 8th phase. You were sitting tight. You will come walking into the picture whenever you feel like. You will deprive the other candidates who were in the waiting list are also part of the 14,052. And moreover, we are facing a contempt. That is why my learned friend was saying we are under pressure, but we are not under pressure. We are facing a contempt because we have not
Time schedule.
within the 4 weeks. And we have also filed a review.
Now you tell me one thing, that this 14,000, let's say.
Yes.
He is one such 14,000.
Yes.
This petitioner who has got the order, in whose favor an order has been passed, is one of such 14,000.
Yes.
Now, suppose his rank is 15, overall rank. Now, this petitioner now gets a permission for counseling. Right? Your counseling will be restricted for these 14,000 only, and those who have appeared in the personality test.
They are those. Personality test means they will either be in the panel or the waiting list.
Right. So if this petitioner has appeared in the personality test and crossed the hurdle on merit there,
Yes.
you are bound to call him for counseling.
Yes, we did.
And this petitioner is one of such 14,000. You called for counseling. The candidate chose not to be there for whatever reason. Then again, by virtue of this court order, she has been allowed or he has been allowed. Right? In the meantime, 3 counseling is over. What impact will it have? Because your boundary is restricted by 14,000. What impact would it have? Your boundary is restricted within 14, periphery is 14,000.
Yes.
You cannot exceed 14,000 plus.
No.
Let's say 14,000 for convenience. You cannot go for 14,001. But you can go for 13,900.
Yes.
Because you cannot get more than that candidate. So the 100 vacancy will remain out of 14,000. If the 100 candidates do not appear or do not come who were within this 14,000, then that 100 vacancy will remain open, will
Yes,
remain vacant.
my lord.
It will be carried out for the next election process. Correct? So you have to roam around within the zone and periphery of 14,000. Right? So how the future subsequent candidates will suffer? You make me understand that.
No, the future candidates in the next selection process, they are entitled to,
Forget about next election process.
oh, in this one.
In this one. Next, it may so happen that your policy decision permits you not to go for any further selection process. Might happen. There is no constitutional binding.
My lord.
So forget about that. Concentrate on this process. Concentrate on this 14,000.
My lord.
What will happen?
Here,
How will it affect future candidates?
no,
I'm
future,
not from the next election
yes,
process.
future meaning those who are now in the waiting list.
Because you cannot go beyond 14,000.
No, no. There is one difficulty. The division bench, while directing filling up of 14,000, there is a slight difficulty in complying with that order. The court overlooked one aspect. 14,000 was the total vacancies. But when I put the vacancies into the categories, there are more than 300 categories.
No, Dr. Patro. What is not there in the
No.
division bench?
No. There is a
Don't
review
put in
pending.
words.
There is,
Forget it.
I have
As on
filed the
date. As on date. As on date.
no,
as
I'm
on date.
applying the court. What
No,
my
no.
court has.
No, sir. You straight take me to paragraph 39 to 42 and make your submission from the division bench decision. Not more than that. Let us not travel beyond anything.
No, but
Review pending, not
Right, sir.
pending.
this is why we are facing contempt. This is why we have filed a review.
Dr. Patro, I am not on that. Division bench is Bible
But
to
this
me.
is before the division bench, the review.
I
this
don't mind. But no, but this, today, as of now, so long it's not being stayed, it's Bible to me, division
Yes,
bench.
yes.
It's a Bible for me. So you satisfy me from my Bible.
Then I can only say that this court, the division bench, the honorable division bench, never directed the commission to go against its rule and allow absentee candidates to come in subsequent.
Taken for consideration.
My lord.
But you cannot travel 14,000 more than
No, I
14,000.
cannot.
You cannot.
No.
There comes the situation that if you cannot travel beyond 14,000, where is the difficulty? You roam around in your 14,000. You roam around within your periphery. You don't go for 14,001.
But
The moment had it been an open selection process, let's say for 15,000, right? But you were directed only in respect of 14,000. Then that question might come. That this one seat will be carried forward to the credit of those balance 100. But here there is no scope. Here there is no scope. You have to be restricted within 14,000. Now, if you have to restrict yourself within 14,000, then where is the difficulty? Because your vacancy is 14,000, candidates are 14,000. It's merely for choosing school.
yes, now the school has to be given as per the category of the candidate. Now there in the 14,000, there are 305 different categories. And that is why we have.
That will depend on the result of writ petition. There the writ court may exercise its equity. It may say the candidate, I don't know. Final decision, very well. Let's not speculate anything. Then the court
But
can
the division
exercise
bench
its
accept
equity.
my contention made out in the review.
Sir, review is not before me.
It is not, but it has
Sir,
been filed. It is before
then
that bench.
I don't mind, sir. But so long no result comes on review, staying this is my Bible.
Therefore, I am not making any argument from that angle. My simple
You
argument
cannot, sir.
is,
You have to restrict your argument.
yes, My
the
simple
division
argument
bench, on
is
the division
that the
bench,
division bench told me to
existing-
direct.
the division bench existing as of date.
Yes. Now, what did the division bench direct me? The division bench directed me that I am to give 14,052 candidates in a panel, put them in the panel and waiting list. Then I am to call for 14.
Not only 14,000, sir. It has also specified those who have crossed PT.
No, all PTs are the 14,000.
Right, that's right.
PT,
So you have 14,000 boys and girls.
yes.
You have 14,000 seats, vacancies, right? It's only counseling is to choose which school where, depending upon their merit. Depending upon their merit, right? So allow them to participate in counseling.
I do not have the schools. I do not have schools which will match their vacancies because
Then
absent.
that submission you can come up in before court of equity. That they have already, since they did not come and join the counseling at their stage, at their respective stage. So they have missed the bus. So they will not get the deluxe version. Now they have to be accommodated. If they are accommodated, they have to be accommodated in the state.
Tomorrow, the counseling held on the 1st is only for 48 vacancies where we have the matching candidates.
No, but
These
48
candidates-
vacancies includes
do not
14,000. It does not go beyond 14,000. 48 within 14,000.
Yes.
Correct.
Yes.
So you have to roam around within 14,000.
I cannot. That is why the review has been filed.
What?
I have,
Sir,
my lord.
that is not my lookout.
No. Kindly appreciate one thing. My lord is directing me to do something which is impossible. I cannot send.
Sir, I will not direct you to do anything. I will give my view and the same direction.
My lord, let me restrict my argument only to the absent point, to the absentee point.
Yes, you can.
Because the other
Absent point you have
the
given.
court
You,
is not
I will.
let me tell.
I shall quote the rule.
Let me tell the court, submit before the court, what is the real position in that matter, since my learned friend has brought it up.
No, but
Because the court is
Dr.
directing
Patro, you have not carried out any appeal.
I've carried out a review.
No.
I've carried out a review.
From the coordinate bench.
Yes, the coordinate bench. I have carried out a review. Sorry, not the coordinate bench.
I'm on
Division
coordinate bench. The moment you have not challenged the coordinate bench, it remains.
Yes. Now, two distinguishing features in the coordinate bench.
I accept.
Place it.
I accept two distinguishing features that they have not participated any of the in-between counseling. I accept.
Not only that, my submission with regard to absentee.
I'm coming. I have not yet completed. I accept that first distinguishing point in between 5 counseling, they chose not to,
And they, especially the
not to
seventh
knock the
phase,
door.
especially the 7th phase.
Correct. Not to knock the door. I accept. I also will deal with your Rule 8
My lord.
and
Rule 5, Clause 8, that is.
whatever. And you have not challenged the coordinate bench. So that remains.
Yes. May I just place one paragraph from the
I
coordinate bench?
will. But in addition thereto, I may give my reason. If I pass this order in favor of the petitioners, then in addition to the coordinate bench, I can give my reason. Because these things were, I do not know whether argued or not by both of you, referring to the division bench and all.
Argument fine.
So I will give that reason. I will also say that your review is pending. I will deal with those. Now you say
Facing a contempt also.
that is up to you.
On this point, that I could not accommodate all 14,000.
Very
And
well.
the delay, and the delay.
I will record your submission.
My lord, one more point just from the coordinate bench's order. Before the coordinate bench, possibly why I could not prevent the court from passing the interim order was the rule was not placed. The term absentee candidate has been referred to, But kindly let me place
No,
in
Mr.
what context it
Dr.
has been
Patro.
mentioned.
Dr. Patro. Even if it was not placed physically, contention has been recorded.
No, how it
Absentee candidate
in a
cannot.
different context it has been said. I have not, it has not been recorded.
All right, I will deal with it.
It has not been recorded here that I have submitted that the rule is creating a statutory bar. What does it say? It says that, okay, let me just read the two paragraphs which concern my argument. Paragraph page 3, Dr. Patro, learned advocate representing the commission has
I got
opposed-
my answer. I got my answer in my mind.
I,
How to deal with it. Yes.
I also understand my boat is sinking, but let me still
All right.
at least try to place
Sir, all of you are open, of course.
the prayer of the petitioner to allow her to participate in the ensuing process in the first state level selection test 2016, since petitioner, in spite of being permitted to participate in the previous round of counseling, did not turn up. So I have objected to the fact that she was absent. It is also submitted at this stage, if the petitioner is permitted to participate in the counseling, if she comes within the zone of consideration, that would make the entire process topsy-turvy. As I am now also arguing, if I add 20, then the 48 who have been called, 20 of them will have to go home
That
empty-handed.
I will demolish by referring to the 3 paragraphs from the division bench. That argument will not stand. That was really troubling me from the beginning. That would it
But
not
that
amount to
division bench
enforcement?
is ordered, unless there is a matching vacancy, I cannot give anybody.
Sir, so long division bench remains in before me.
But we are
This is
facing
my
contempt.
Bible.
We have 3,500 leftover vacancies, but we
have-
don't have any matching candidates.
Very
That is the point we are facing in contempt.
very
Then let the division bench be concluded, and then these matters should
It's
be heard.
concluded before it's
No, no,
it's
the review
concluded.
is pending, the contempt is
All
pending.
right, all right, all right, all right. You make your submission.
So that would make the entire process topsy-turvy. In this context, I am saying that an absentee candidate should not be allowed.
Absolutely.
I did not say it with regard to the rule being a statutory bar. It is submitted that a stand has been taken on behalf of the commission that absentee candidates are not to be permitted to participate in the ensuing counseling process. There was no reference to the rule. It was simply said that since they were absent, since their inclusion now would make the process
Will it
topsy-turvy.
matter? Will it matter?
No, because there is a
The-
statutory
the-
bar which the court was
Pitan-
not
Pitan-
aware of.
Pitan substance has has been considered. That absentee cannot have any right.
But the
That's
fact that
Pitan
there was a
substance.
statutory bar,
All right.
that was not placed. That is all I can submit. But with regard to the 14,000 vacancies which the division bench has told me to fill up, I'm facing a contempt. In the contempt, I have filed a CAN application for passing further directions so that the order may be complied with, because we do not have the vacancies.
Achha,
We've
Mr.
also
Bari,
filed a review because that observation of the court to a certain
you
extent
show me
is incorrect.
where you have disclosed that day after tomorrow is the date, the notice.
Notice is there.
No, unless it is part of record, I will not take up.
This is open, Dr.
No,
Patro.
no, no.
But nobody's case, it will
No,
not
no,
be case
no,
in
no,
the
no.
G9. Your lordships kindly. Dr. Patro submitted, I submitted, throughout the Bengal is
No.
submitting.
But
You'll-
still. These are the matters.
Within half an hour, supplementary affidavit disclosing this.
Come tomorrow. I don't mind.
Supplementary তে বলেছি আমরা।
Your supplementary should have contained this.
মানে is
No.
it required?
I will, yes, of course, required. Of course, required. In this
notification.
type of matters, of course, required. Of course, required. Of course, required.
মানে every day we are placing before you, my lords, that this
Sir,
notification.
maybe my practice may be different. In this type of matter, no question unless something is on record.
Keep it at 2, I am placing this.
No, tomorrow, sir.
Because your lordships have heard the matter.
That's right, tomorrow.
Only 2 p.m. 2
I'm
pages.
recording this. I'm recording this.
I believe no further hearing is required, only for.
No. If required, I mean, it will appear regularly as it is. Ashun.
Only one.
Mr. Ekramul Bari, learned counsel appearing for the petitioner, has pressed for an interim relief in view of a notification for holding 8th phase counseling dated July 24, 2025 for the post of assistant teacher in connection with first SLST for upper primary level classes, 2016. In compliance of the order of the Honorable Division Bench passed in MAT 638 of 2021. Paragraph. The petitioner was scheduled, petitioners were scheduled for counseling on
1st August 2025. Earlier.
first
11th June, na?
On different dates. That is the difficulty when they club so many candidates.
on
All in
different
November.
dates, on different dates from time to time. After being qualified at the personality test level. The petitioners, for some reasons, could not participate on the day the counseling was scheduled. Full stop. In between, several counseling have already taken place, and now the petitioner prays for direction to allow them to participate in the 8th phase counseling, comma, as referred to above. Full stop.
Yes.
The writ petition on this interim prayer. Acha, now, top one. The coordinate bench had already considered the writ petition on May 14, 2025. But in view of the said subsequent development dated July 24, 2025, having the 8th phase counseling notice being published, the petitioner prays for an interim order for participating in the counseling process. Paragraph. Mr. Bari has referred to a order dated June 9, 2025, passed by a coordinate bench in the matter of Mukti Bishwas versus the state of West Bengal, rendered in WPA. এটা দেখে একটু লিখে দিন আপনি, এখনই লিখে দিন। Comma, where the petitioner therein was allowed to participate in the 7th counseling held in June,
11th June 20.
held on June 11, 2025. Full stop. The petitioner prays for identical interim relief. Paragraph. After a substantial hearing having taken place, after substantial hearing having taken place, this court finds that the said notification for 8th phase counseling dated July 24, 2025, though the existence and publication of the said notice has been admitted by Dr. Shutanu Kumar Patro, learned counsel appearing for the West Bengal Central School Service Commission. But since the said notification has not been made part of the record, today's hearing stands adjourned. Poster. The petitioner shall be at liberty to file supplementary affidavit in the writ petition disclosing the said notification dated July 24, 2025, and the matter shall then be taken up for further
Course
consideration.
of the day, matter related reports.
Poster.
My client is here, I'm doing it within half an hour.
Considering the urgency involved, as the counseling is fixed on
Faster.
August 1, 2025, the writ petition shall once again appear under the heading motion top tomorrow. Don't wait for the order. Don't wait for the order.
No.
Even if it is not placed, it is understood.
We are doing it supplementary evidence within half an hour. I'm serving copy upon Mr. Dr. Patro and also Mr. Miller.
এগুলো রেখে দাও বাবা, সব গুছিয়ে রেখো। Oh, good.
Extremely grateful, my lord. The Lord says,
It is always pleasure to hear all of you.
we are disturbing every day.
No, why disturbing, sir?
The urgent matters are being back.
This is my job. Where is the difficulty? No problem.
For the in this matter, you will recollect this is the second round of litigation. The earlier petitioner, being a homeopathy doctor, engaged by this Railway Staff Benefit Fund Committee, approached with your lordship on the ground that though he has been position has been upgraded, it was later on downgraded and the honorarium was also cutted. So challenging that, my lord, the petition was filed, and I also made a representation. Lordship's order will appear at page 86. Lordship has directed the concerned authority to issue a prior notice, hearing notice to us, and we will.
86. 86, the previous order.
Yes.
Okay, then they have rejected again.
No, my lord. They need. Lordship directed them to issue a prior notice to us, and we will go there. We will place our case on the basis of the circulars, but without issuing any notice to us, my lord, they have straight away rejected. Now,
Show me the order of rejection.
page 96. Now, my lord,
Let us be very candid, madam. Please, let us be very candid, madam. What is your instruction? Tell me. Has notice been given? Effective notice.
No, Lordship.
Madam, you are an officer of the court. You tell the court, I will simply set aside this and give a fresh time frame
Lordship.
in terms of that order.
Yes, Lordship.
That's all. So as an officer of the court, you assist the court.
Yes, Lordship. That can be, Lordship.
Give me
can-
the instruction, I'm taking it on record. আসুন। Yes.
Lordship, the thing is that in the first round of litigation, I appeared along with.
Forget it. After my order, you tell me. Come to page 86. 86.
yes, the order passed.
And show me the compliance. That's all.
No, Lordship, I'm not telling that. I'm not on that. But this time, department has provided me the instruction, but MOL not yet engaged me in this matter.
But you can regularize
Ministry of Law and Justice yet not engaged me in this matter.
You are appearing for which respondent? Tell me.
All respondents.
Matter ends.
But ministry, whenever means this is our system, ministry.
Even if the union has not engaged you, come to cause title. for whom you can appear today.
For the all respondents, Your
You
Lordship.
can appear today.
Yes, Lordship, as department has instructed me,
So which department? Tell me.
3 and 4.
3 and 4.
I'm recording 3 and 4. are
Lordship,
appearing.
but this is the system. Whenever I can appear
Who
for
was
3 etc.
directed to here?
Lordship, respondent number 3 was directed.
To here.
Yes.
Yes.
So I'm saying you are appearing for 3 and 4.
Yes, Lordship. But when Lordship kindly regularize my engagement, Lordship. As per your direction, I can appear only.
All right. Ask. But you are
Otherwise-
instructed on behalf of 3 and 4.
Yes, Lordship.
Mr.
Saptarshi Roy.
Saptarshi Roy, learned advocate appears for the petitioner. MS.
Tanushree Ghosh, led by Mr. Kumarjyoti Tiwari.
Mr. Tanushri Ghosh, learned advocate, led by Mr. Kumarjyoti Tiwari, learned senior advocate, appears for respondent number 3 and 4. They have received instruction from Assistant Welfare Officer for the Deputy Chief Personnel Officer within bracket W. Indian Railways. এটা দিদি এই নিচেরটা লিখুন, নিচের জায়গাটা সইয়ের জায়গাটা দেখে লিখুন। In comma Indian Railways. Full stop. Copy of the instruction letter dated July 2, 2025. Placed before this court is taken on record. Paragraph MS Ghosh submits that till now there has been no engagement by the Union of India and by respondent number till now they have not been engaged formally on behalf of respondent number 1 and 2. Full stop. Paragraph. Considering the issue involved in this writ petition, both the learned counsel, MS Ghosh and Mr. Tiwari, are requested to appear for respondent number 1 and 2 to assist this court in the matter, and their appearance shall be regularized by the appropriate authority of the respondent number 1 and 2. Forthwith.
Grateful, Lordship.
Paragraph. This is the second round of writ litigation on the self-same issue. Paragraph. The first writ petition WPA 8393 of 2025 was disposed of by this court by an order dated May 7, 2025, Annexure P14 at page 86 to the writ petition. 86 to the writ petition. শুনুন দিদি, কোথাও যদি কোনো অসুবিধা হয় আমার সঙ্গে সঙ্গে থামিয়ে দেবেন, কোনো প্রবলেম নেই, 15 বার থামিয়ে দেবেন, কিন্তু ওই না বুঝে বেরিয়ে যাবেন না চেপে। কি বললাম, আজকে কে আসেনি আমাদের টিমে? কি হয়েছে, ওনা আসছেন না সদস্যদি? ওরা তো রেগুলার, আমার টিম সব রেগুলার। আচ্ছা দেখুন কি বললাম। Posted. Under the said order, the respondent number 3 herein was directed to consider the writ petition, consider the representation of the petitioner after granting an opportunity upon prior notice of hearing and after granting an opportunity of hearing to the petitioner, comma, in the mode and manner as directed in the said order dated May 7, 2025. Paragraph. Learned counsel for the petitioner refers to the impugned reasoned order passed by the respondent number 3 dated May 24, 2025, annexure P16 at page 96 to the writ petition, and submits that neither any notice of hearing was served nor any opportunity notice of hearing was served, nor any opportunity of hearing was granted to the petitioner as directed by this court on May 7, 2025, and the impugned reasoned order was passed. Poster. Paragraph. Learned counsel appearing for the respondents has placed reliance upon the written instruction dated July 2, 2025, comma, as referred to above. First. From the said written instruction, it appears to this court that no contrary material has been produced before this court to controvert the plea of the petitioner, as controvert the plea, PLEA, taken by the petitioner as recorded above. The record, now full stop. The stand of the respondent number 2 and 3 suggests on the face of it that opportunity of hearing was not granted to the petitioner. Paragraph. Accordingly, the impugned speaking order dated, speaking order থেকে bold, dated May 24, 2025, A of the board, comma, annexure P16 at page 96 to the writ petition, comma, stands set aside কথাটা bold and কথাটা normal, set aside and quashed কথাটা bold and টা normal, full stop. Paragraph. The respondent number 3, in strict compliance of the direction made by this court in its order dated May 7, 2025, shall conduct the hearing and then passed its reasoned order in accordance with law, full stop. The time period fixed in the said order dated May 7, 2025, the time period, time stipulation. Time stipulation, কি বললাম? Shall remain unaltered and without any modification, and same, but the same shall reckon from the date of communication of today's order. ঠিক আছে, সেম বাস এই হয়ে গেল। Paragraph. Since affidavits are not called for, allegations made in this writ petition are deemed not to have been admitted by the respondents. Paragraph. It is made clear that this court has not gone into the merits of this writ petition.
There's only one. I should be allowed to at least place certain documents and circulars.
Is it not there?
It's there, my lord. The way they have disregarded the court's order.
this direction is mandatory. First paragraph. The writ petition bold numberটা bold হয় আমার WPA 13967 of 2025 stands disposed of, comma, without any order as to costs. Specifically said,
Actually, next matter is also same. Item 4, same.
same,
Show me.
where is your instruction?
Same, one instruction has been given only.
Same impugn speaking order, my lord. The name was
Page,
page 98.
কি আছে annexure গুলো বলুন আমি বলে দিচ্ছি।
And lordship's order is at page 88.
হ্যাঁ, এটা ওখান থেকে নিলেন, হ্যাঁ, তো ওইখানে রাখুন না, ওটাতে গেঁথে রাখুন। ও ঠিক আছে, আপনি ওখানে গেঁথে রাখুন, কিচ্ছু অসুবিধা নেই। কি বললেন? Page of my
Lordship's
order,
at page 88. And impugn speaking.
7th May, এটা 88 হচ্ছে প্রথম আমার অর্ডারটা। ওই একই অর্ডার হবে দিদি, শুধু ফ্যাক্টস এন্ড ফিগার একটু চেঞ্জ, আমি বলে দিচ্ছি। লিখুন May 7, 2025, annexure P14 at page 88 to the writ petition. 88 to the writ petition. আচ্ছা, পরেরটা হচ্ছে স্পিকিং অর্ডারটা ডেটেড ওই ইমপিউন রিজন অর্ডার May 24, 2025, annexure P16 at page 98 to the writ petition. মাথার উপরে দুটোতেই affidavit of service filed in court today is taken on record, লিখে দিন মাথায়, একদম শুরু হবে, তারপর appearance। ঠিক আছে, হয়ে গেল। What else? No facts and figure?
If
ওই instruction সব এক হবে। Five? All right, I'm coming within 5 minutes.
Lord, we are suffering an interim order. Your lordship knows, my lord.
You argue.
Then they should join, my lord, subject to the final outcome of the petition. They should join to the transfer post, my lord.
District administrative, accounts manager, district accounts manager.
My lord, purely on contractual basis, 2 points were raised, whether it lies against the committee and my lord, second point, my lord, whether they have any legal enforceable right to seek a writ of mandamus. My lord, last 4 weeks, my lord, we are suffering an interim order. The entire, my lord, process and
Convince him.
Lord, I cannot stand in the way if Mr. Bhattacharya ground is taken, because he would not spare me in the downstairs. That I know. Very difficult, my lord. So, my lord,
So you're taking the protection of the court. Come tomorrow, but if he is not there tomorrow, don't pray for any accommodation. Don't embarrass the court. Don't go for any accommodation, right? Don't embarrass the court.
my lord, let it retain its position.
কিসে আছে এটা? হ্যাঁ, ঠিক আছে। Just passed over for the day.
Lordship.
Yes. Yes. Who is on the other side?
I have served them, but they have not appeared.
Show me the affidavit of
The
service.
affidavit service, I will file it in course of this day, but
Come tomorrow. Affidavit of service. Passed over for the day. You are there? You are there? So
it is appearing.
who is the answering respondent?
Snehas is the petitioner. He is the, he refused that already order has been passed. I will not take it. I am given them a mail.
He, who are you?
I am for the corporation against whom the order has been passed. The statute says, my lord, they have not explained before your lordship at the time of hearing. The consideration will be done by the district magistrate, not by the commissioner of corporation. It is a highway authority. I have the statute with me. My lord's order has been passed. Only with that modification that the district magistrate instead of commissioner, I will show.
What do you say?
I can show Mr. It is a highway authority.
No, look, show it to him. Show it to him. Show it. Wait, Mr. De. Show it to him. Make him understand what you want.
I am showing. এই দেখুন এটা হচ্ছে হাইওয়ে অথরিটিতে কে হবে ডিস্ট্রিক্ট ম্যাজিস্ট্রেট বোঝা
অ্যাপ্লিকেশনটা দিন
only modification কমিশনারের জায়গায় ডিস্ট্রিক্ট ম্যাজিস্ট্রেট স্পেসিফিক্যালি লেখা আছে
আপনার হাওড়া মিউনিসিপাল কর্পোরেশন এই করবে রিপ্রেজেন্টেশন আগস্ট 9 2023
and who is the appropriate authority that is also annexed
হাইওয়ের মধ্যে পড়ে জমিটা তো হাইওয়ের মধ্যে বলছে সেকশন 5 বলছে স্টেট গভর্নমেন্ট মে বাই নোটিফিকেশন ইন দি অফিশিয়াল গেজেট অ্যাপয়েন্ট ওয়ান অর মোর অফিসার্স অ্যাজ হাইওয়ে অথরিটি ঠিক আছে কৃষ্ণা ম্যাডাম লিখে আছে এই সেকশন 5 এর এই নোটিফিকেশনটা দিয়েছে notification under section 5 of the Regional Highways Authority Act যেখানে এক্সিকিউটিভ ইঞ্জিনিয়ার হাওড়া ডিভিশন ইজ দি অ্যাপ্রোপ্রিয়েট অথরিটি জিটি রোড নিয়ে মামলা তো এক্সিকিউটিভ ইঞ্জিনিয়ার হাওড়া
as per section 5
as per section 5 of the এটা স্টেট গভর্নমেন্টেরই নোটিফিকেশন আছে বাই দি গভর্নমেন্ট কনসিডার কে করবে এটা কনসিডার করবে এক্সিকিউটিভ ইঞ্জিনিয়ার হাওড়া ডিভিশন
সেখানে লিখা আছে এক্সিকিউটিভ ইঞ্জিনিয়ার কর্পোরেশন নট
হাওড়া ডিভিশন
হাওড়া ডিভিশন
পিডব্লিউডি
that has been annexed
only this much
Yes, so the authority, mere change of authority.
yeah change of
It's all right? Bas, chalo, আসো। দেখি,
oh, it's a marked copy
না না ওটা দেবো না
এটা কি?
that is the notification
Oh, statute.
section 5
Which section?
section 5 says section 5 I am placing section 5 that is the page 2 inner page 2
Yes, appointment of highway authority.
The state government may by notification in the official gazette appoint one or more officers to the highway authority for the purpose of the act.
এইবার পেজ 16
And now page 16 of my application. Annexure C. Number so and so dated so and so in exercise of powers conferred by section 5 of the act
so and so, appoint with immediate effect the highway authority within the meaning of clause D of section 2 of the Act, as mentioned in column 4 of schedule below, in respect of road and its length under the Public Works Department in Howrah district. As
Which
made-
serial number?
my lord, that is the number 4, is the GT Road, Uttar part of D Garden. That is the my lord, executive engineer Howrah division, PWD. I have given him.
Otherwise, my lord,
What copy?
your modification for which has come.
I have given.
The application. ব্যাস চলো আসুন মিস্টার মিস্টার সন্দীপন ব্যানার্জি learned advocate with Mr.
Ankit Sureka,
Ankit Sureka, learned advocate, appear for
Howrah Municipal Corporation.
appear for applicant stroke / the Howrah Municipal Corporation. Mr. Chondi Charan De, learned additional government pleader, appears for state. Paragraph. None appears for the writ petitioner, comma, despite notice. Paragraph. Where is your notice?
মেলটাও দিয়ে দিন, মেলগুলো দিয়ে দিন, সব মেল দেয়া আছে,
Notice of derives,
সার্ভিস এর, মেশনিং এর, and after আজকেরও intimation, all mails.
All mails.
The notices shown to this court show that due notice had already been served both
Upon the petitioner and the state.
state to appear হয়ে গেছে on the learned advocate on record for the petitioner on email
On email.
and you have served upon the petitioner also
Upon the petition.
and also upon the petitioner on email. Full stop.
My lord, that is the, according to Highways Act, my lord, your lordship was pleased to direct the executive engineer to demarcate the land. After that, my lord, that motion has gone to the SDO, not to the commissioner of Howrah Municipal.
Yes, Commissioner of Howrah Municipal Corporation has been directed, that cannot be.
That cannot be.
That is a higher SDU.
All right. Act minute. Full stop. This order shall be effected subject to filing of affidavit of service by the applicant in course of the day.
I shall.
কোন portion এ modification হবে বলুন?
Madam has passed the order, Madam comes to the order itself.
This is an application seeking certain modification in the order dated March 10, 2025, Annexure A at page 12 to the writ petition.
Third, in view of the above, the executive engineer.
এটা না, এই মডিফিকেশনটা বলুন।
Focus shall cause a physical inspection of encroachment and construction and shall submit his report before the petitioner.
Who shall do that? Executive engineer?
Engineer, my lord.
Highway division,
Highway division.
Page 16.
16.
page 16.
Howrah division.
আচ্ছা আসুন on the joint submissions, sir, I'm recording joint submission, both of you. On the joint submissions made by the learned appearing counsel for the parties, the following modification are made. Modifications are made. Colon, Roman 1. In the last paragraph of the first page of the order dated March 10, 2025, the expression executive engineer, ECAP, shall be read and understood as the executive engineer,
Howrah Division,
Howrah Division,
in terms of section 5 of the Highway.
PWD.
Howrah Division.
PWD. PWD.
Acha. The executive engineer, PWD, Howrah Division.
So good.
কি লিখলেন বলুন এইটা পুরো বোল্ড হবে রোমান 2
And instead of
সেমিকোলন দিয়ে
next page, just in the next page.
and করুন সেমিকোলন and তারপর নিচে রোমান 2 yes
Next page, submit his report before the respondent. It will be before the respondent. Instead of commissioner, it will be only district magistrate Howrah.
No district magistrate.
Then SDO.
No, ওটা ছেড়ে দিন না।
না ওটা বলতে হবে তো commissioner কে দেবে। SDO. SDO.
so in place of commissioner it should be
SDO হাওড়া।
SDO Howrah. And not the district magistrate also.
Subdivisional.
লিখুন in the third paragraph in the second page of the said order dated March 10, 2025, the expression commissioner, Howrah Municipal Corporation should be replaced.
And the district magistrate. Because he is the appellate authority.
No, third paragraph পড়ছি।
It is third paragraph.
হ্যাঁ, third paragraph.
Yes, yes, ma'am. I'm sorry.
Page 13 first paragraph should be changed well. As because my lord his report before the commissioner Howrah Municipal
And this. It will be
আচ্ছা ঠিক আছে লিখো ঠিক আছে লিখুন কি লিখলাম and বলে রোমান 2 লিখুন wherever in the order dated March 10, 2025, the expression appears as commissioner, Howrah Municipal Corporation, the same shall be replaced by
and the district magistrate Howrah.
and the district
Magistrate Howrah. Both are
commissioner, Howrah Municipal Corporation and district magistrate Howrah shall be replaced
by subdivision.
By executive engineer.
no. Subdivision. No.
No,
Subdivision officer.
executive engineer.
SDO.
Subdivisional executive, subdivisional.
by the jurisdictional subdivisional officer,
Howrah Sodor.
Howrah Sodor. He's not happy.
Your Lordship, Section 5 notification specifically says that executive engineer Howrah Division PW. Now my lord is finally passing this order. That is why I was just clarifying that section page 16. The notification for Howrah states that it is specifically bestowed upon executive engineer Howrah Division PW.
No. Commissioner Howrah and district magistrate. Where I have written district magistrate.
The second page,
page.
first para. Your Lordship, the bottom line of the first para of the second page of your Lordship's order dated
It is made clear.
of the
Where,
order.
where?
Your Lordship, Commissioner Howrah Municipal Corporation and the district magistrate Howrah.
কোথায় লিখেছি সেটা?
In the second page. at the
Page
first-
13 of our application.
হ্যাঁ, page 13 which paragraph?
Third line from up. Third line from the top.
From the top.
Third line.
Yes,
Your Lordship.
ঠিক আছে। তাহলে এক মিনিট লিখবেন না। Commissioner Howrah Municipal Corporation and District Magistrate Howrah is replaced by
Executive Engineer PWD Howrah Division.
SDO করতে হবে তুমি
Section 16 kindly seize the page 16 of our notification which we have brought.
Sir, I don't mind. I will write. Then again, if
And or Your Lordship and or the SDO. And or SDO.
and or SDO.
I can't agree with that. As because my lord 10,
কেন
1,
করাচ্ছ
2 and 3 my lord.
Let it be. Your Lordship. Let
My
it
lord
be.
has already written executive engineer in place of corporation, that has been PW has already been written. Already been, it is my lord, it's,
Now my lord, it is
now-
10 3, that is his.
ঠিক আছে, তাহলে কি লিখলাম বলুন?
now appropriate,
Roman 2.
ঠিক আছে, যাক, যাক।
SDO হবে।
Please listen. Wherever and district magistrate. The comma দিয়ে the same shall be replaced by the expression jurisdictional subdivisional officer, Howrah Sodor. Howrah Sodor. That's all. Paragraph. Paragraph. The rest of the order
Only time may be extended.
dated
I don't know.
March 10, 2025 stands unaltered and without modification. 7, except that the time stipulation mentioned in the said order dated March 10, 2025 shall remain same, but shall reckon from the communication of today's order. Paragraph. Accordingly, comma, can 1 of 2025 stands disposed of, comma, without any order as to cost.
So great.
Next.
This one and applicant, how do
You say that.
For the petitioner, your lordship. এটা আর করছি হুকুমের
কত নম্বর এটা?
ফুল করে দেওয়া হয়নি for the petitioners, your lordship. For the petitioners, your lordship. Here the reply of the report, your lordship.
So 9187, let us do it first.
Your lordship, shall I initiate this matter with 9188? It is quite necessary, your lordship. Just in your cooperation, just to elaborate my facts.
I don't
in an arranged way.
Not arranged,
Intentionally, my lord, I just want to place my submission in a harmonious way. That is why I need to initiate this matter with.
You are briefed in 9188?
Yes.
You are briefed?
Yes.
9188. Sure.
The reply of the report, your lordship.
What is this?
Reply of the report. We have filed the report.
In both?
Both the reports appear. I have filed the reply. Yes.
1 second. Ashud. On the prayer of the petitioner, though these writ petitions are fixed for though these writ petitions are fixed for analogous hearing, but WPA 9188 of 2024 is taken up for consideration first, and then the next, and then WPA 9187 of 2024 shall be taken up for consideration. Paragraph. On the prayer, next paragraph. On the prayer of Mr.
Shubhodip Pramanik.
Shubhodip
Pramanik,
learned advocate appearing for the petitioners in both these writ petitions, comma, trying to file exception on exception in the form of affidavit.
Reply of the report, your lordship.
Exception, that is the exception. Exception in the form of affidavit to both the writ petitions filed in court today. Time to file exception on affidavits, exceptions on affidavits to both these writ petition stand extended till today. Full stop. The exceptions filed in both the writ petitions are taken on record. Full stop. Copies have already been served. Ebar korun in re 9188. It are hearing already. Good. Yes. Proceed.
Your lordship, it's a ICDS Anganwadi worker and helpers recruitment scam, your lordship. I need to tell the facts in a nutshell, your lordship.
What do you claim? First tell me.
Lordship,
What is your claim in the writ petition?
I'm gradually coming to this point, your lordship. Just
First, let me know what is your claim in the writ petition. What do you claim?
your lordship, I just need recruitments. I have been deprived arbitrarily. Recruitments has been given to the others. Chosen pickup policy has been applied.
Acha.
I have been deprived.
Final list published. Final list published.
Yes, your lordship.
Your names were not there. You take your seat. Take your seat. Both of you
if your
take your
lordship
seat.
kindly
Madam, you
allow me
take your
to-
seat.
If your lordship would kindly allow me to tell the
I
fact.
will. I will. Why do
Final-
what makes you so afraid that I will tell you? Now, final list, merit list has been published.
Yes, your lord. Yes, your lordship.
You are not
My name
in
is
that
in
list.
the list.
You are not in the list.
Yes, but the first list has been the candidates from the first list has been deprived by not giving the appointments, and suspiciously, the candidates of the second list has been given appointments.
But your name is never in the any of the list.
I have not got any appointment letters.
But your
But
name
my
was
name
there.
is in the list.
আচ্ছা, সেটাই তো জিজ্ঞেস করছি
Yes, yes,
এতক্ষণ
yes.
ধরে. So you were empaneled.
Yes, your lordship.
You were empaneled, but you have not been given with the appointment letters. Yes, tell me.
Lordship, the petitioners applied for the post of Anganwadi workers and helpers in an integrated child development services scheme under government quota. As per their applications, your lordship, at first through a notification dated 25th
Any
February.
reason was communicated to you why you were not selected?
No, your lordship. To be honest, no.
Is
25th
there any
February?
chance of dishonesty?
Definitely, your lordship.
Alright.
No, sorry. Apology, your lordship.
All right.
Apology. Your lordship, as per their applications, through a notification dated 25th February 2020, the ICDS Director, West Bengal, sought for a inquiry report as per the eligibility of the applicants. There were 28 applicants. Page number, annexure P1, page number 15, your lordship.
First, you show me that you were empaneled.
Yes,
Any
yes,
document?
I'm coming to that. As per, accordingly, your lordship, the DPO, District Program Officer, suspiciously after 1 year, issued 2 notices successively but at a time. Annexure P3, your lordship. 2 merit lists were published through notification dated 8 February 2021. DPO issued this notice to the director of ICDS. In this notice, your lordship, there were actually 2 lists. First list, page number 19, comprising out of 8 candidates. And I beg your lordship to kindly come to page number 19, and the status shows that all are eligible. Dolon Mukherjee, Khukumoni Mahato, Podda Acharya, they are all applied from Kasipur block. And from this list, it can be seen that all are eligible. Whether eligible to the post of AWW, AWH, Anganwadi worker, Anganwadi helper. Yes, column number 8, your lordship, all are eligible. Thereupon, your lordship, depriving those candidates at first.
Are you any one of them?
Yes, definitely. At first, 5 candidates, they filed a writ
Show
petition.
me which page.
Page number 19, your lordship. Page number 19. Serial number 2, Khukumoni Mahato. Serial number 6, Amola Rajawad. Serial number 8, Simarani Mahato. All are eligible. Column number 8,
Serial-
yes.
Wait, slowly. Yes, who are your clients, petitioners?
Lordship, Khukumoni Mahato,
Right?
Serial number 2. Serial number 6, Amula Rajwar. Serial number 8, Simarani Mahato. Column
Then-
number 8, Your Lordship. Here it is the status report, whether they are eligible or not. Yes. They were eligible to hold.
Where?
Column number 8, Your Lordship. Whether eligible to the post of AWW/AWH.
With or
Column number 8. 1, 2, 3,
whether
7, 8. Whether
eligible to the post, yes.
of AWW/AWH.
All yes.
Yes. We were eligible. But surprisingly, Your Lordship, we have been deprived. And
What
ironically,
about the next column?
Lordship,
What about the next column?
whether vacancy is available. It is blank. It is blank, Your Lordship. No status is there. কোথায় লিখা আছে?
So no vacancy was available.
Definitely, vacancy was there.
Here it appears no vacancy was available.
At that time, they showed that. Actually, artificially, crisis of vacancy has been created.
All
I'm
right,
coming
then-
to that point later.
Then
Ironically, Your Lordship, there is a second list. 15 candidates has been given appointment.
show me.
There were 8, but later on, depriving them, 15 candidates has been given appointment, Your Lordship. Page number 20. Page number 20, 21. Annexure P4, Your Lordship.
Wait. Yes.
Annexure P4, page number 22. Appointments have been given to the candidates of the second list. Here is the appointment notification, Your Lordship.
Page 22.
Page 22. Annexure P4.
Nineteenth August.
Page number 22.
What is the date?
19th August 2021. No, 21. No. 21.
21.
Yes, 21, Your Lordship. 21. 2021.
Appointment.
Appointment has been given.
Your client's name were not there.
No.
Huh?
No, Your Lordship. 2 eligibility report has been prepared.
Second eligible reports, candidates were incorporated.
Yes, Your Lordship.
First candidate,
They have been deprived.
yes.
My lord, challenging these discrepancies, at first we filed a writ petition before this Honorable High Court. 5 petitioners were there from the first list. 8 candidates, 5 petitioners were there. And Honorable Justice Lopita Banerjee, after considering the demands of the petitioners, Your Lordship, pass an order, come judgment. Page number, Annexure P6, page number 56, dated 31st January 2023.
Yes.
I would like
No.
to read out the effective portion, the observation of the court, Your Lordship.
What
of
was
said
the,
judgment.
what was what she held?
he has passed an order directing the concerned respondent authorities to give us recruitment, to appoint us within 3 weeks. Page number 70 here is the last portion of the order.
So
Lordship, I just,
all 8 petitioners were directed to be given appointment.
no, there were 5 petitioners, only petitioners.
Whatever,
Yes.
5 petitioners were directed to be given appointment.
Yes, Your Lordship.
Then what happened?
I will just read out certain effective portions of the.
Sir, first tell me what happened to this judgment.
We have completed the judgment. 5 petitioners has been given appointment.
Appointment.
Yes.
These 5 petitioners were not included, these petitioners.
No. Those were there were 8 candidates. At first, 5 petitioners were filed the writ petition, and there are 3 writ petitioners from the said list.
So you say that you are similarly placed.
I did not got your lordship, what your lordship said.
You say that these petitioners are similarly placed. You are still taking.
Page number 60, your lordship. Honorable Justice Lopita Banerjee opined that taken her observation as per para A, I'm just reading it out. As per the list of vacancies prepared by the district program officer, there were 21 vacancies for the post of Anganwadi workers and 38 vacancies to the post of Anganwadi helpers. Prepared for forward to the CDPO. Sorry. Next page, your lordship. Apology, your lordship. Next page, para D. Para D.
Para?
Para D. Page number 61, para D.
Yes.
No reason was provided by the director of ICDS for his pick and choose policy of recommending the names of 15 candidates for engagement from the second list only. Why the candidates who were found eligible from the first list that was forwarded almost 1 year before the second list of candidates were not considered for appointment has not been explained either in the recommendation made on 19th August 2021 or in the report filed by the respondent number 4 or the director pursuant to the directions passed by the court on November 15, 2022. The only issue that has been argued in the said report is with regard to the fact that the Anganwadi workers and the Anganwadi helpers have different causes of action and the writ petition is not maintainable for joinder of causes of action. Kindly turn over the next page, your lordship. Para E. There is no explanation on merits for the willful failure or deliberate omission on the part of the director of ICDS, respondent number 4, to recommend the names of the 8 eligible candidates from the first list dated 25th February 2020.
These 8 includes you.
Yes, your lordship.
Huh?
No, in the observation, 8 candidates has been mentioned.
Were you included?
No, in the last order, your lordship, in the next page number 73, page number 70, your lordship. the petitioners whose names appeared in the first list dated February 25th, 2020 and subsequently recommended as eligible candidates on 8th February 2021 to be appointed immediately and not less than 3 weeks.
I have seen
The
that.
petitioners only. The court directs that the petitioners whose name appeared in the list. So at that time, we were not petitioners. So we have not given appointments.
You were not there before the court.
At that time, we were not there.
That's right. Now you have come, showing that your name is there in the two list.
Your Lordship.
No, not two list, in the first list. Page 19.
First list.
Page 19.
Your Lordship.
And you were found to be eligible also.
Lordship.
But appointment was not granted to you. That's your case.
No such justification has been given by
Right.
them, any of them.
What happened to that order? Any appeal carried out
No, Your Lordship.
from that judgment?
Uh,
Justice Banerjee's judgment, any appeal carried out? Any appeal was preferred?
no, Your Lordship.
No.
No.
Yes. Then
Your Lordship, this is my prayer to kindly give them appointment because in this case,
Acha.
it is very
what
much
is
clear
their
that
stand?
that-
What is their stand in report? Show me.
Yes, Your Lordship.
Filed by them.
The report, Your Lordship, page number 2, para 3. That I state that the writ petitioner Khukumuni Mahato applied for Kasipur block in the district of Purulia for seeking appointment as an Anganwadi worker under Kasipur block in the district of Purulia under government quota, but their applications were not a general one for the state as a whole, but they filed applications for consideration of the candidature of Kasipur block, but as per guidelines, they are to be considered according to their resident and under which block they reside. To be noted, Your Lordship. This para is completely contradictory to the next para.
All right.
Next para, Your Lordship.
Now read on. Since Khukumuni Mahato resides under Huda block.
Khukumuni Mahato resides under Huda block. As such, Khukumuni Mahato was considered for Huda block. Amola Rajawad resides under Kasipur block. As such, Amola Rajawad was considered for Kasipur block. And Simarani Mahato resides under Adra Kasipur block. There is no Adra Kasipur blocks. Actually, it is Kasipur block.
So
As
you
such-
are received appointment. Have you received appointment at those blocks?
No, Your Lordship. This actually they are showing they are trying to elaborate that as because they are from their residential block, they have made their applications from residential block, and at that time there was no such vacancy. That is why they were unable to give any kind of appointment. But this portion is this para is contradictory to the next para. In the next para, Your Lordship, it is written at 2-3. Line number 3, Your Lordship. Mariam Bibi, from the mid portion, Mariam Bibi, Dolon Mukherjee, Nomita Mahato, Mitali Chakraborty, and Podda Acharya in serial number 10, 11, 16, 17, and 18 of the inquiry list at page number 12 have
Now,
been given.
three, paragraph 3, who are named are these petitioners?
Yes, from the
Khukumuni,
first writ petition.
Amola, Simarani. Wait.
Those are the 5 candidates who has been given appointment after filing writ petition.
Yes.
Mariam Bibi, Dolon Mukherjee, Nomita Mahato, Mitali Chakraborty, and Podda Acharya. These 5 candidates in serial number such and such and such of the inquiry list have been given appointment in Puncha, Kasipur, Purulia 2, Kasipur, and Raghunathpur 2. To be noted, Your Lordship, one thing. In the previous para, they said,
এই এটা লিখে রাখুন তো জাজমেন্টটা দেখতে হবে WPA 3566 of 2022, 66 of 2022. জাজমেন্ট ডেট হচ্ছে 31/1/2023। লিখে রাখুন দোলন মুখার্জি and others versus state. Yes,
They said that Mariam Bibi, Doron Mukherjee, they have been given appointment from Puncha block, Purulia 2 block, Kasipur block, and Raghunathpur 2 ICDS project in Purulia district respectively. That means they have been given appointments from different blocks. Now, these Doron Mukherjee, Mariam Bibi, Nomita Mahato, Mitali Chakraborty, Podda Acharya, they are from the first list, their name. I beg your lordship to kindly juxtapose one document, your lordship, page number 19. Page number 19 of the main writ petition, your lordship. The first list, first eligibility list.
yes.
Here, Dolon Mukherjee, Dolon Mukherjee,
Kashipur,
Nomita Mahato, all are from Kasipur. The residential block are from Kasipur.
but they have
But
given
they have been given appointment in different blocks. Both the reports, both the two paras are contradicted to each other. Actually, in this entire recruitment issue, certain rapacious political leaders are involved. They are puppeting.
Forget
This
it,
is actually fact, your lordship. Like primary, upper primary recruitment.
let us concentrate first on law, then we will see the fact. Extraneous facts will be seen later. First,
This
let
is
us
the
see.
actual fact. Elephant in the room.
All
your
right,
lordship. Elephant in the room.
all right, let us, you better concentrate first on your record and law. Then, so you are arguing discrimination, hostile discrimination.
Arbitrary recruitment is there. Choose and pick up policy has been applied. Nearest and dearest one of the political leaders has been.
Have you been issued with the appointment letter?
I didn't got.
Have you been issued with the appointment letters?
No, your lordship. কি আমি বুঝতে পারছি না actually. কি বলছেন?
না আমি বলছি এই রিট পিটিশনাররা অ্যাপয়েন্টমেন্ট লেটার পেয়েছে, যেখানে ওরা অ্যাপয়েন্টমেন্ট পেয়েছে এই যে প্যারাগ্রাফ 3,
Paragraph 3, yes. Yes, they have been given appointments and right now they are in their job.
তো এরা ওখানে কাজ করছে।
Yes, your lordship, they are.
Now you are seeking different place. That's right. কাজ করছে তো?
Yes.
Yes, what is your submission next?
This is the first petition, your lordship.
So appointment, there is no problem. You have received appointment.
In the writ petitioners of the first writ petitioners, they have been given appointment. Right now, we have not given any appointment, your lordship. Right now, in this writ petition.
This Kukumoni
Mahato,
Amola
Rajwar,
Simarani.
Yes, they have not got any kind of appointments.
They have not received any appointment. Then why paragraph 3 to their report is said they have given
they will answer.
So this is your matter.
This is my matter, your lordship.
That's all. The second other writ petition is the petitioners are different.
Yes.
But the case is same.
Case is same. Their name is in the first inquiry report issued by the ICDS.
Forget
it.
Yes. So you are over with your submission, or you will make further submission?
No, I have completed I have already elaborated my facts, my grievances. If they.
All right. Of course. Very well. Yes. What is your defense? In the light of your paragraph 3, 4, read with page 19 and 20 of the writ petition.
Paragraph 3 and 4. But
3 and 4.
3 and 4. But I have in my exception.
Have you issued the appointment letter?
Yes. To whom?
These 3 petitioners?
No. They are the writ petitioner here. Now they are claiming.
Sir, have you issued any appointment letter in favor of these 3 writ petitioners?
No.
Why? Because your paragraph 3 says they are eligible for appointment.
Yes, but I'm coming. But they have filed a writ petition, can you see? But I have mentioned in my, if you are kindly next, in my report, I have given that.
Come to paragraph 3 of your report.
First of all, my lord,
আমাকে রিপোর্টটা দাও।
Sir, kindly take paragraph 3 from your report.
yes, my paragraph 3 from report.
Read it loudly.
Well, read the-
You take your seat. Read loudly.
that I state the petitioner Kukumani applied for Kashipur block in the district of Purulia for seeking appointment as honorary worker under Kashipur block in the district of Purulia under government quota, but that applications were not a general one. Your lordship, in the other day, your lordship asked me to file report whether the application made by the petition in general or block wise. I have filed my report stating that they made the application block wise, not general. And paragraph 4, I shall show that who made application in general, they have been given the appointment. But leaving aside part of the order of the Honorable High Court, 5 writ petitioners who filed the writ petition, in view of the writ petition, my lord, the 5 writ petitioners were given appointment.
So why don't you give this?
Now, there is no vacancy. First of all, they made application for block wise, and the same
Those
block,
writ petitioners also made application blockwise.
but the pursuant to the order of the Honorable High Court, my lord.
So I am now ordering you
now-
give appointment
But
tomorrow.
now I am to see, but now they have pointed out that they have made these block wise. They have made
Sir,
no
kindly
address
read
is
your
given.
3 and 4. Read
no.
it 3 or 4.
They
3
have
and 4.
my lord, they have given subject to also consideration. They in the may I come from the writ petition so that it would be easier.
You concentrate on your case.
Yes.
3 and 4. Read 3 and 4.
There are 3 and 4. Now, my lord, they have shown that the persons who were given appointment, first of all, my lord has my learned friend shown the circular that later dated 25th. This is may I take the help of writ petition. Just I am coming. my lord. That is paste, your lordship, they place the paste where? No, tomato, writ petition. I am coming one by one. That's so that I can make submission to your lordship. But
You read your para 3 and 4.
if I read paragraph 3 and 4, then I am to explain from the writ petition, the circular, that what is the 3 and 4. Now we have given appointment, my lord, in block wise, and my learned friend shown that Kukumani, he is saying that Dolan Mukherjee has been given appointment. Now, my lord, it is the address. He says that this is the address, residential address is here. But whether the application were made in general or block wise, that is to be considered, my lord.
Sir, the persons you have been given appointment,
My lord.
they have been given appointment by virtue of the judgment of the coordinate bench.
Yes.
They were also placed similarly circumstanced.
No, but I shall show the application 1 to the respondent number here, my lord, 1, 2, 3, 4, 5. But they made application not in general, not block wise. As such, they were given
Okay,
in
very
general.
well. You show me from Maniram Bibi. Show me Maniram Bibi. Show me Dolan Mukherjee. Dolan Mukherjee. Which page? Dolan Mukherjee.
But this is the
Annexure 1.
no, their name 25th February 2020, but this is placed here for 28 persons application, but annexure P1, but dated 25th February 2020.
Page.
Annexure 1.
P1
Page.
page there, no pagination in the petition. Okay. One.
Annexure
1, 25th,
The-
Feb 20. 25th,
25th February.
yes,
Come to page 19.
page 90.
Dolon is serial number 1.
Yes, Dolon is serial number 1. But this is inquiry summary report. Can you see?
Residential address is Kashipur.
Yes, yes. All are, but there are
To take one by one.
Madam,
Dolon residential address is Kashipur.
Kashipur. Dolon filed for this petition.
Right?
Madam,
Right. Now she was appointed at
she was appointed, but I have not got the appointment later, but where they have been appointed. They are the petitioners. 1 minute. They are the petitioners. Yes, Dolon Mukherjee was the lead petitioner. I mean, what happened here, my lord, that those made in general application, not mentioning the block, they have been given appointment according to their address, in which block they reside.
So you also give them their address according to their address.
No, then, my lord, what happened when the report has been made, my lord, it shows that there is no vacancy because there is a limited vacancy. My
Sir, you will not give appointment on illegal plea and then you will come and say no vacancy.
no.
You will give others and you will pick and choose.
Can listen. This appointment, this notification was issued in the year 2020. Now, my lord, the appointment was given 2021. Kindly see, 21. They never
Judgment
approached.
judgment is of 23.
Yes, 23. Now, my lord, 23, 20, in the year 21, appointment was given. Thereafter, my lord, the writ petition was filed, my lord, in the year 2022. Kindly see, they did not turn up. They did not turn up. Now, my lord, after giving appointment, in view of this order of the Honorable Court, 5 vacancies there, 5 vacancies have been filled up. After delivery of this judgment, they come and made representation there in the month of November 2023. Kindly see. In the month of November 2000.
So you give them appointment at their wherever they have residential. I don't mind. Give them appointment at the residential place.
But kindly see, their names where only inquiry was made. No panel. Kindly see, they have said that final panel was made. They cannot show that there is a final panel for appointment.
Sir, in the facts of the writ petition which has been decided, kindly come to page 56.
Yes,
Judgment.
Yes.
Show me that they were in the panel.
No, their name is, yes, there is summary report, their name is there. And also, their name is also appearing in the first list, which sent for inquiry. Well, first, what happened? Most probably 28 persons, they made application for getting appointment in the post of Anganwadi worker and or Anganwadi helper. So, inquiry was made and that inquiry report was sent. And thereby vacancy wise, my lord, appointment was given. But the writ petitioner herein, my lord, they are the fence sitter. They remain mum till the judgment comes. So, my lord, till November 2023, there is no whisper by the petitioners, please give appointments has happened. Other persons have been given appointment. We have not been given appointment. So, they remain fence sitter till the judgment of the Honorable Court comes. After this, my lord, these 5 persons have been given appointment by virtue of the order of the Honorable High Court. So, where the vacancies, was there.
Take instruction and come back.
My lord. Lordship, may I place one objection?
This question
about is talking about vacancy.
I shall.
Is talking about vacancy. At first, 8 candidates were there. They told there are no such vacancy. That was why they have been cancelled. Thereupon, subsequently, they have been
take instruction from your client. You take instruction from your client, this judgment,
yes,
and their appointment. If you will accommodate these petitioners, appoint them, I will dispose of the writ petition. Elsewhere, I will have to hear you, and if I find you have to, I will direct.
I will also, your lordship knows better than me that the mere enlistment.
Fair enough. But this judgment is there. You have accepted this judgment.
Yes. Yes, accepted judgment so far as the petitioner is concerned in the said judgment.
That's right.
That is not in name, my lord. This is in persona. So, my lord, they were the fence sitter And after having this judgment, they come before this, made representation,
Your
then
Lordship.
come before this court. But I will make submission, I take instruction, madam.
Your Lordship, on 25th February 2020,
Yes.
report has been sought for by the director SCDS. After suspiciously after 1 year, the in eligibility report has been placed after
Then
1 year,
then
and in the meantime, such kind of corruption was going on.
Not that, not that. How could
Ashin, Ashin, Ashin,
but it is there, his case, he has to substantiate. So,
ওই দুটো রিট পিটিশন একসঙ্গে অর্ডার হচ্ছে, ঠিক আছে? ইন রে এটাই বলেছি না, ওটার তলায় লিখুন।
রিপোর্টটা দাও, আমি তোমার জেরক্স করে দিয়ে দেব।
হ্যাঁ দিদি,
ওর কাছে নেই ওটা।
report তোমাকে দিলাম কি?
না,
In the light of the judgment dated January 31, 2023, Annexure P6 at page 56 to the writ petition. And in view of the facts that the writ petitioners in WPA number 3566 of 2022 have already been given appointment, comma, the learned State Council shall take instruction from the appropriate authority whether at the present situation appointments can be granted to in favor of the writ petitioners in both these writ petitions. Full stop. The learned State Council, sir, shall make his submissions on the next day. Full stop. Paragraph. It is made clear that today's order shall not create any right or equity in favor of the petitioners. Full stop. Full stop.
এক্সেপশনটা কোথায় নিয়ে যাও? আমার
আমারটা জেরক্স করে দিলে না আজকে।
এটা অন্য একটা পরে তুলে দিচ্ছি তো, তুমি তো দেবোই, দিতেই হবে।
Depending upon the instruction comes, comma, this writ petition shall be considered further. Paragraph. In re, পরেরটা করুন, WPA 9187. নিচে লিখুন, in view of the order already passed in the previous writ petition, WPA 9188 of 2024, identical about the
আমার এক্সেপশনটা দাও।
no further order is required to be passed in this writ petition,
এর মধ্যে ঢুকে গেছে দেখো।
and the same instruction shall be taken by the learned State Council in this writ petition also. Full stop. Paragraph. Similarly, paragraph, this order shall not, today's order shall not create any right or equity in favor of this these writ petitioners. Full stop. And depending upon the instruction comes, comma, further hearing shall take place. In Shurid, both the writ petitions shall appear under the heading for orders. On author, Aji Gautam.
29 তারিখ।
August 18,
Mal, mal,
2025.
mal.
Full stop.
Grateful, your lordship.
Paragraph.
দিদি আমাকে জেরক্সটা করে দিও, হ্যাঁ?
No, 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 no. Instruction.
No, but you take instruction in writing.
Yes, yes.
You take instruction from the appropriate authority in writing,
Mal, mal.
so that you can file
Yes,
it.
yes,
to the
mal,
court.
yes, mal. That will be better for us, mal. So the burden.
You also it will be. কি বললাম?
দিদি ভাই, দিদি ভাই, দিদি জেরক্সটা বলে দিয়ে মনে করে
Just করে দিন।
জেরক্সটা মনে করে দিই।
For further consideration.
ঠিক আছে।
Thank you.
Grateful, your lordship.
মাথায়
Gratefully, Your Lordship.
মাথার উপর অ্যাফিডেভিট অফ সার্ভিস বলা
Original site mentioning.
Your Lordship, may I permit to mention one matter, Your Lordship, for drawing up the order dated 24/6/2025, Your Lordship.
Drawing up.
Drawing up, Your Lordship. Drawing up your.
You filed the requisition when? When your requisition was filed?
Your Lordship, it is not been filed, Your Lordship.
So how?
Your Lordship, they are saying that for extension of time because 7 days statute.
7 days, yes, 4 days or 3 days, 7 days.
Has been passed, Your Lordship. So I am praying for leave, Your Lordship.
এটা তো পেছনে এন্ডোর্স করতে হবে। রিকুইজিশন নেই তো, রিকুইজিশনটা তো পাচ্ছি না। এটা তো চিঠি। হ্যাঁ, এটা চিঠি, এটাই রিকুইজিশন। You have not applied for the certified copy
Your
within
Lordship.
time.
No, Your Lordship.
Leave granted to leave granted to draw up and complete the order dated 24th June 2025. Annex করেছে অর্ডারটা। এটা ফার্স্ট পেজ অফ কস্ট টাইটেল দিয়েছে। Leave granted to obtain, to draw up and complete the order. Just one second. One five seven.
ACC online, Allahabad. বুঝছি তো।
আজ তারিখ কত? Yes.
But here, but this is that Escheat matter. But we are on the last occasion where we had stopped at a
15 July.
yes.
You have placed, lastly, you have placed definition of escheat 2G, then Article 296 of the Constitution,
Yes.
and rightful owner, Yes.
Therefore, my lord, I had drawn your lordship's attention to, my lord, Article 296 of the Constitution.
296.
Yes, 296 of the Constitution.
কি হয়েছে দিন কাগজ লাগবে দেখার
Some of them.
Yes.
Now, my lord, my argument was, my submission was that the West Bengal Act is not a statute by which property vests through escheat or lapse or bona vacantia. But it, yes,
West Bengal Act?
West Bengal Act of this
No,
is
I don't want
yes,
that.
but what I yeah,
Describe your point.
my point is number one, that the concept of escheat that is devolving on the state properties
Close
which
from
are
Constitution.
close from the Constitution.
All right. Yes.
Therefore, the next question will arise, then what is the purpose of the West Bengal Act of 2012? Willard, the purpose of West Bengal Act of 2012 is not to vest property, but it is a mechanism to give somebody who claims ownership an opportunity to revert that.
Opportunity to the
To
objectors.
to objectors to establish their title. This is one part.
এটা চলছে তো? Is it good? Yes.
And the other part of 2012 Act is to provide for the procedure of taking over management and possession of the properties which are vested. These are, Miller, two broad purposes of this Act.
Yes.
Miller, the Act is, Miller, annexed at page 83 of the writ petition. Kindly have a look, Miller. Kindly look at the preamble of the Act.
Yes.
Page 83. Please have a look to the preamble first. An act to provide for taking over charge, management, administration, supervision, custody, and disposal of property vested in the state by escheat or lapse or as bona vacantia and unclaimed property. This is not a statute under which, Miller, the state gets the right.
State
gets the right, or this is not a statute by which, Miller, the property vests in the state by escheat, lapse, or bona vacantia.
So the difference, just for discussion, difference between Land Acquisition Act and this Act. By virtue of exercising power under Land Acquisition Act, provision being sanctioned by Constitution, state takes the property and get it vested. Here, you say that the vesting is pursuant to the constitution. It is only the procedures.
Procedure for two purposes. One is if somebody claims ownership, he can come and raise objection and prove his ownership. And the second is how to take over possession, how to take over charge,
The
etc.
modalities.
Modalities. Now, please take me, Lord, section 1, subsection 3.
So according to you, it is more a procedural law than a substantive law.
Right. Right. There are a few substantive parts like Millard appeal and all that.
No, that is the remedies. Yes, yes.
Now, please have a look to below the definition of escheat under 2G. Escheat with all its grammatical variation means the automatic transfer. This is very important. Means the automatic transfer to the state of property of so and so, so and so, so and so. Or in other words, you do not need a mechanism for transfer.
So it is already transferred
But
by virtue of constitution.
Yes.
Simply you will go and take the property.
Yes.
Now, if it is already transferred, so does it presuppose that there is no scope for any further objection if it is already transferred?
If it is transferred, then and then only, Milord, there is a scope of objection. Because as I was submitting...
So not at the transferable stage.
No. But could I make this submission? Any property, immovable property, cannot remain ownerless for even half a second. There may be a dispute on ownership.
Perfect.
Therefore, where a situation arises that a property becomes ownerless for XYZ reasons, the state automatic becomes
the
owner by way of escheat. Now it may so happen that somebody may say that, you see, I am a distant relation of the owner who have passed away.
But has left a will for me.
Left a will. Yes, left a
For
will.
me.
Yes, yes. Then he can go and Millard establish his ownership. Then what happens is the automatic transfer that had happened goes.
Nullifies.
Becomes non-escheat. This is the purpose.
So you are saying, sir, that first vesting, then following the procedures under the statute, if situation so arises in accordance with law, then revesting.
These are all provided. I'll take your lordship through.
And not revesting, then revert back.
Yes, it reverts back. Therefore, this automatic transfer happens under Article 296. With the rest of the, Section 2G, I don't trouble your lordship for the present. Then 2H is escheated property. It means land, building, etc., etc., which has vested or having become vested or shall vest in the state by escheat or lapse of bona vacantia under the provisions of this act. Then please unclaimed property, I don't think that is important. Then we need to place section 3. Notwithstanding anything contained in any other laws for the timing in force, where a person dies intestate and without leaving legal heirs, according to his personal law, or any corporation, trust, association, or society, or the governing body of such corporation, trust, association, society, by whatever name called, recognized by law to be capable of owning property, whether in his own name or in the name of any governing body or office bearer, by whatever name called or otherwise, the transfer to the state government of the property of such artificial person on its dissolution, winding up, becoming defunct, whether by operation of law, declaration, or in fact, or has ceased to exist, or is unable to hold the general meeting and reconstitute its new executive committee consecutively for the last 5 years, property of such person or artificial person, as the case may be, shall automatically stand transferred to the state government, and the state government may cause possession, management, or administration of such property to be taken over by escheat or lapse or as bona vacantia for the rightful owner, and on such transfer having taken place automatically on such finding of fact as referred in clause G of section 2 by the competent authority, the state shall become the owner without any further act or document being needed. Therefore, automatic transfer and without requiring any further activity or executing any documents. Therefore, transfer or vesting by escheat doesn't happen under this statute. It has happened.
So, according to you, it is more a statute for releasing the property if situation arises.
If situation arises, and other things like taking over administration, possession, because the property may be ownerless and I may be possessing that. It has transferred to the state, got transferred to the state. Therefore, the
How will you go and take possession?
Yes, take possession.
It's all right.
How the state will administer the property.
But you say that according to you, property has already been vested, then notice, objection, hearing, and if ultimately it appears that yes, property should be reverted back, it will be reverted.
It gets reverted back once the ownership is proved. Now this has got various stages. Milord, we are at the first stage. The present litigation is at the first stage. Now, please take section 4. It shall be the duty of the collector of every district to send monthly reports to the competent authority of the occurrence of death of persons or dissolution, winding up, etc., provided in G of section 2 of any artificial person having property within his district, whether such property is partly or wholly within his district, and whether it appears on a preliminary inquiry that the deceased persons died intestate without any legal heirs according to his personal law, or where there is no legally constituted successor entity in whom the property of the artificial person has vested. Any person whatsoever may send information to the collector in this regard, or may send such information directly to the competent authority. Whenever, well, this is one part, there is a full stop. Then, whenever the competent authority on any report or on receipt of any information from any source, or next part, next phrase, part of the phrase, or on his own motion, is satisfied that the provisions of this act applies to any property within the state,
he shall cause an inquiry to be made as to whether the fact or facts as stated in clause G of section 2, as would attract the operation of section 3 of this act, exists or exist, and on being satisfied on such inquiry that such a fact exists, he shall pass an order accordingly, recording that such fact exists, on which order recording the existence of such fact, the property shall belong and be transferred automatically to the state government without any further act or document being required. Then subsection 2, the inquiry held under subsection 1 shall be of summary nature, and for the purpose of inquiry the competent authority may summon and examine on oath any person and may compel production of any document or thing. He shall have all the powers of a civil court, etc. Then subsection 3, for the purpose of such inquiry the competent authority shall cause to be published in the official gazette or in any 3 newspapers having wide circulation in the locality where the property is situated a notice informing the public in general of such report or information having been received, and that an inquiry is proposed to be held on the expiry of not less than 7 days from the date of publication of such notice, and the time and place of such hearing and the particulars of the property concerned. The newspapers should be so chosen as to ensure that they are in English, Bengali, Hindi or Urdu respectively. But this has been done. Then comes, Millard, the right to prove the ownership. Subsection 4. Any claimant or person intending to appear in such inquiry with an intention to oppose escheat or lapse and automatic transfer of title to the state government may appear on the date of such inquiry at the time and venue fixed with a written representation containing the particulars of his claim and the right which he claims in the property, including the reasons for his opposing escheat or lapse as the case may be, and shall enclose with such representation copies of all documents that he relies upon, and shall also produce before the competent authority the originals of such documents. If the copy of any document is not enclosed, then the claimant or person shall not be entitled to rely upon it. The competent authority shall thereafter pass an order recording his satisfaction that such fact as mentioned in clause G of section 2 sufficient to attract the provisions of section 3 exists or does not exist. Therefore, if the fact under 2G exists, state. If it does not exist, the person who goes and opposes has proved his ownership. This is the purpose. Therefore, section 4 up to subsection 4, the purpose is to
give the fullest opportunity to the objector.
And thereafter to record whether 2G and 3 circumstances exist or not. If it does not exist, no escheat. Then kindly take Miller, the explanation may not be that important because it speaks of letters of administration. Miller, apropos this, 4 subsection 4, please have a look to Miller, the relevant portion of the order under appeal of the show cause notice at page, it starts at page 81, where relevant at page 82. The opportunity is being provided by section, page 81. But this is the notice made under 4.3. Please take me look, page 82, penultimate paragraph in the form of recital. And whereas the competent authority made after the schedule. And whereas the competent authority therefore desires to cause an inquiry to be made as to whether the fact or facts as stated in clause G of section 2, as would attract the operation of section 3 of the Act, exist in respect of the aforesaid land described above. Well, this is exactly, my lord, what your lordship has found in subsection 4 of section 4. Please take, my lord, page 86 at the bottom once more. Last 3 lines at page 86. And please compare it with page 82.
Yes. Yes, sir.
So this is the right that he has. Then, my lord, the point of objection that I had raised on the last occasion, subsection 5 I skip over for the time being to be gazetted. Please take subsection 6. Well, right or wrong, my lord, I have said that the circumstances exist after giving them the opportunity of hearing. Now, subsection 6 of section 4. The decision of the competent authority shall be subject to an appeal before the appellate authority, which shall be made within a period of 30 days from the date of publication of the gist of the order in the manner mentioned in subsection 5, provided that the appellate authority may allow for sufficient cause being shown an appeal to be preferred within a further period of 30 days, but not thereafter. The appeal does not have to be in any particular form, but shall contain a concise statement of the grounds on which the appeal is being preferred, and all the facts of the case, and shall enclose with it the representation made by the appellant before the appellate authority with all its enclosures. If a person has not made any representation before the competent authority, but shows that he has the interest mentioned in explanation to subsection 4, but this is not our case, therefore I don't trouble your lordship with this, then such appeal shall be maintainable, provided that such person explains in a separate application what prevented him from approaching the competent authority with such representation, and on satisfaction in writing recorded by the appellate authority to cause as to the cause for such prevention being sufficient. The decision of the appellate authority shall be final and not be interfered, etc. Now, this is one stage. We are at the first stage where our preliminary objection on the day of moving of the writ petition was that there is an efficacious remedy under subsection 6 of section 4 by way of an appeal. I'll come back to this. Now, in further details, I'll come back to this. Now, please take me note, section 5. This is the next stage, or the taking charge stage, section 5. On an order, as in subsection 1 and 4 of section 4, being passed and its gist being notified in the manner mentioned in subsection 5 of section 4, the competent authority may direct the collector to take steps to take over possession, management or administration of the escheated property, and for that purpose the collector may at once take charge of the escheated property. Unless otherwise directed, the charge may be taken in the following manner. So, competent authority directs the collector, you go and take charge. The collector will at once take charge. How will he take charge is the next part.
So this is after the order is passed.
Yes.
declaring it to be escheat, rather negating the objections.
There
Not
are-
declaring, because according to it is already declared. So negating.
Whether the circumstances under 2G read with 3 exist or not. Then kindly similar, if your lordship recollects, your lordship was wondering at the initial stages of the hearing, what happens to the persons if someone else is claiming ownership? What happens to them? These are Miller taken care of Miller under subsection under section 5. Please have a look to this. A. In case of immovable property, a notice shall be served on the person, if any, in possession of the property, and where is in such and where is in such person.
No, but this is, Mr. Advocate, this is after negating the objection.
Right.
When the authority state shall go and take possession, what
Yes.
are the procedures to be followed?
Yes.
But we are at the stage of objection, receiving objection.
Right. But this, to be very honest, Miller, I do not require to place section 5 onwards. I am undertaking this exercise only because at one point of time your lordship was wondering that you have given notice to Port Trust. Very well. Port Trust have or have not been able to prove its ownership.
What will happen to the
The
world
other
at
person.
large? World at large.
Yes. That is taken care of by the subsequent sections.
So that is taken care of post-objection stage.
Yes, because that stage where it has not yet come.
Post-objection.
Yes. But we have given an oral undertaking, I think at one point of time it has been recorded also,
No,
that so long your lordship is hearing this matter, the subsequent steps will not be taken.
Absolutely.
Yes.
But pre-objection stage, I was wondering at the pre-objection stage,
Right.
that if I look at this notice, how can I identify that 6,000 square feet was there somewhere, my maternal uncle's property. How can that be done?
But to that, where your lordship may kindly look into their objection to the notice. It has been handed up to the court, Miller,
in a bunch.
Yes, in a separate, I think, spiral বা কিছু একটা ছিল.
একটা ওই যেটা বাঞ্চ আছে দেখুন. Yes.
এই বাবা, বৃষ্টি পড়ছে কি? Well, Mr. Sen tells me that it's not the climate to argue matters. You can't be serious in this climate.
Absolutely. Who wants?
Just ask your officers to open the door.
আজি ঝড়ো ঝড়ো মুখরো বাদল দিন জানিনে কিছুতে কেন গো মনো মানে না.
Mr. Shamrat Sen knows all this. I don't know these.
You only sing.
Yes.
You only sing.
There's also here.
Without looking into it.
No, I have to look into it. But old songs I remember.
Nowadays you have to look still, or
old songs I can remember.
That's right.
But in those days, when we were boys, we didn't have those tape recorders and all that. But once or twice in a month, we used to hear in the radio. We could memorize it. Yes. Amin Sani. But Amin Sani is still alive, কিন্তু. Yes. Amin Sani আর ওই ভদ্রমহিলার নামটা কি ছিল? ওই গুলশান কি নামটা বলো আগে ভদ্রমহিলা? হ্যাঁ, মোটামুটি হ্যাঁ। হ্যাঁ, ফুল ক্লিয়ার গুলশান একটা ছিল। Now, this reply, kindly similar, what is the reply? Tabassu.
Yes, sir.
But this is dated 23rd of April, but I'll not trouble your lordship with it in its entirety. Please take paragraph 4. From the schedule of the notice and the reply and the attached sketch map of KMC, it is seen that a substantial portion of land falling within 12 bighas and 7 kathas, which is admittedly belonging to our client, above named and has also been included in the schedule of the notice under reference, whereas the order of the Honorable Supreme Court clearly records that the state government is not disputing the title of our client in respect of 12 bighas and 7 kathas. Hence, inclusion of a portion of the land falling under the admitted 12 bighas, 7 kathas of land is in total dereliction and flagrant and contumacious violation of the solemn order of the Supreme Court. Therefore, the first contention is that why have you included 12 bighas and 7 kathas, which is admittedly our land? This is the first grievance. Then the next is, it is relevant to mention here that the jurisdictional facts necessary to invoke the provisions of the Escheat Act are to be found in sections so and so. But I skip over, my lord, the rest quoted part. Then para 6. In your notice, there is no recording as to the existence of any jurisdictional facts as aforesaid, in the absence whereof the provisions of the Act cannot be invoked. These jurisdictional facts, in fact, do not exist in the present case also. The procedure laid down under the Act also mandatorily ensures existence of jurisdictional facts before any vesting order can be made. This procedure under section 4 requires the collector to send monthly report of to the competent authority of the occurrence of the death of human being or dissolution, winding up, defunct of artificial persons having property within the district. The report should also state whether the deceased human is having legal heirs or dissolved, or the dissolved artificial person's property has vested in any entity. Section 4(1) kindly forward such report, without which the Act cannot be invoked. Then, in addition to the above, it is relevant to mention here that SMPK is having right title interest in respect of lands as mentioned in the schedule of the said notice under reply by virtue of indenture dated etc. 1874. I don't trouble your lordship with that. Then paragraph 9 speaks of another indenture. Para 10 speaks of a third indenture. Para 11 speaks of a fourth indenture. Where there is a subparagraph 2, para 11, which says, that is also not important. Then kindly take paragraph number 12. From the aforesaid, it would be evident that by virtue of the aforesaid deeds of indenture, dated etc., SMPK is the owner having unbridled right title interest over the land in respect of which the purported notice under reply has been sought to be issued. Then para 13, it says that since such and such period, they are exercising all the rights of owners. Similarly, paragraph 14, they say that KMC is regularly raising bills. That is para 14. Para 15, again, KMC is collecting tax. Then para 16 says that various notices from various authorities have come to them in respect of those land. 16, 17, 18, these are all governmental acts recognizing them as owners. 19, again KMC. 20, 21, then para 22 high-handedness, etc. And finally, in para 25, it is said in view of the facts, it is apparent that the notice under reply is malicious, arbitrary, etc., etc. Now, this is below the objection. Therefore, fundamentally two things. One is that the jurisdictional facts are not stated, and number two is
not
that
stated in the notice.
In the notice. And number two is the report which the collector is supposed to receive under section 4.1. That report there is no such report, or if there is any such report, forwarded to us. These are the fundamental two things, and then we'll have those documents, indentures to prove their ownership. Now, my lord, on that, my lord, today the competent authority has passed an order. The order may be a good order, the order may be a bad order. Now, my lord, when there is a provision for appeal, whatever they are saying, my lord, in my very respectful submission, can all be agitated before the appellate authority. Therefore, my lord, I come back to my first point of objection or the point of demur, that when there is a provision for appeal, my lord, ordinarily, unless, my lord, that those 3 or 4 exceptions which your lordships have carved out, but unless, my lord, those are satisfied, my lord, in my very respectful submission, my lord, there is no scope of entertaining this writ petition, ignoring, but again, I don't say, my lord, that the writ court cannot. But whether this is a case,
Self-imposed restriction.
yes, self-imposed restriction, and whether, my lord, this is such an exceptional case that your lordship will withdraw from this self-imposed restriction to entertain this writ petition. But 1 or 2 judgments on that, and then, my lord, I'll, if your lordship requires me, my lord, I will, my lord, deal with each of the points which have been raised.
No, but you have to file your note.
Note. Yes, yes, note I will definitely file. Only may I only, my lord, for my understanding, if I may say so, my lord, since I am raising a point of jurisdiction, do I stick to the point of jurisdiction that your lordship would decide, and then if your lordship feels that the matter should not be relegated, then of course, my lord, I can address your lordship on the merits of the matter.
You can complete
Very good.
in
Very good.
all respect.
Very good. Very good.
You can complete in all respect, and you will file your note, Mr. Advocate, in all respect, whole hog, whatever you want, whichever way you want. So show us the judgments.
Yes, but I'll not multiply decisions.
So what multiplying question does not arise because you have not yet placed 1.
No.
No.
I'll
Correct
place
me.
1. I'll place only 1.
Which one? No, you have not placed 1. No, it is for, I was confused, the multiplying.
No,
because
what
you
I
have not yet
intended to
placed.
say that is
That's right. That's all right.
Well, 2022.
Otherwise, আমাকে আবার সব নোট পড়তে হবে,
না, না,
কোথায় মিস করেছি কি।
পড়তে হবে না। But these are all well settled, 1 or 2 minute only.
Sir, you are free to argue, no issues.
But 2022, volume 17, Supreme Court
Wait,
cases.
sir.
2022, volume 17. I'm sorry, volume 17.
17.
SCC 332.
Paragraphs
7, 9, 12, 13, and 15.
Yes, এই ফাইল তৈরি করুন কেসের। এটা রেসপন্ডেন্ট, হ্যাঁ, স্টেট এজি সাহেবের। এই তারিখ কত? Yes, sir.
Please check para 7. See, Sachin Patil learned counsel appearing on behalf of the appellants had vehemently submitted that against the assessment order passed by the assessing officer under the provisions of the Act, the High Court ought not to have entertained the writ petition under Article 226. Then 7.2.
Yes.
Or 7.1 also, may I please? It is next submitted by the learned counsel that the SSC had a statutory alternative remedy available by way of appeal before the first appellate authority, and the said remedy ought to have been pursued, more so because there were very serious disputed facts as to the assessment, as to whether the assessment order was passed on so and so or so and so. Making the above submission and relying upon the decisions of this court in so and so, it is prayed to allow the present appeal. Then kindly take, Millard, paragraph number 9. Yes, paragraph number 9.
1 second, sir.
Yes.
Yes.
Sri Rafiq Dada, learned senior advocate appearing on behalf of the respondent SSC, has relied upon the following decision of this court in support of his submission that the High Court has rightly entertained the writ petition against the order of assessment, so and so judgments. It includes, Millard, the third one, Whirlpool, which is mostly cited. Then para 12. At the outset, it is required to be noted that against the assessment order passed by the assessing officer under the provisions of the Act, and the SSC straightway preferred the writ petition, it is not in dispute that the statute provides for the right of appeal against the assessment order passed by an assessing officer and against the order passed by the first appellate authority and appeal revision before the appellate tribunal. In that view of the matter, the High Court ought not to have entertained the writ petition under Article 226, challenging the assessment order in view of the availability of statutory remedy. At this stage, the decision of this court in Satyavati Tandon, in which this court had an occasion to consider the entertainability of a writ petition under Article 226 by bypassing the statutory remedies, is required to be referred to. After considering the earlier decisions of this court, in paragraphs 49 to 53, it was observed as such and such. I skip over those where it has extensively quoted Satyavati Tandon. Then please take, Millard, paragraph number 14 and 15. Applying the law laid down by this court in the aforesaid decision, the High Court has seriously erred in entertaining the writ petition under Article 226 against the assessment order, bypassing the statutory remedies. Now, so far as the reliance upon the decisions of this court by the learned senior advocate appearing on behalf of the respondent referred to herein above are concerned, the question is not about the maintainability of the writ petition.
Where?
We got para 15, 1.5.
1.5.
Yes. Now, so far as the reliance placed upon the decisions of this court by the learned senior advocate appearing on behalf of the respondent referred to herein above are concerned, the question is not about the maintainability of the writ petition under Article 226, but the question is about the entertainability of a writ petition against the order of assessment, bypassing the statutory remedy of appeal. There are serious disputes of facts as to whether an assessment order was passed on so and so. No valid reasons have been shown by the SSC to bypass the statutory remedy of appeal. This court has consistently taken the view that when there is an alternate remedy available, judicial prudence demands that the court refrains from exercising its jurisdiction under constitutional provisions. In that view of the facts, the High Court seriously erred in entertaining the writ petition. Therefore, Millard, Supreme Court says that some valid reason has to be shown to the court or the 226 court to bypass an alternative remedy. Now, what is said is that the jurisdictional facts are not stated. And the number 2 is that the inquiry, the reports which are contemplated under section 4.1, those are not, has not been supplied. I have answers for both. But,
sorry.
but these two basic points, apart
Uh-huh.
from whether they are the owner or not, the documents have been given.
First is jurisdictional fact not stated.
Not stated. Second is that the reports which are required to be prepared under section 4 was not provided. Collector. Now, these 2 points, whatever may be its worth, can also be agitated before the appellate body.
Quorum.
Because as your lordships have always held that an appeal is a continuation of the original proceeding. So whatever they wanted to say, wanted to ventilate, all can be ventilated once again.
Question is, if I entertain the writ petition, again, quoting from the Honorable Apex Court, no question of maintainability. Maintainability, yes. Question is of entertainability. On entertainability, if I entertain in this fact circumstance, I have to give reason why the situation is such.
It is not the court's obligation. It is the petitioner's obligation to provide for some valid reason to persuade the court to entertain a writ petition despite the availability of the other remedy. So the obligation is of the petitioner. In my very respectful submission, the point that the jurisdictional issues is absent in the notice, or that in the reply to the show cause, as they have said that the collector's report has not been provided. These, in my very respectful submission, does not make out a valid reason. I borrow the Supreme Court's words, valid reason for the court to entertain.
Crystallize. Listen, crystallize.
But
in
one sentence.
Oh, I was thinking for 2 sentences.
Very good.
One.
Yes.
Tell.
But in one sentence, my lord, the non-mentioning of the jurisdiction. The non-mentioning of the jurisdictional facts relating to satisfaction of section 2G and 3 of the Act and the alleged non-supply of reports under section 4 within bracket 1 of the Act are not, within quotation, valid reasons cited by the writ petitioner for entertaining this writ petition despite section 4(5), bypassing the statutory remedy under 4 subsection 5.
Thank you.
And what is second 2 sentence?
ছ লাইনে একটা সেন্টেন্স। Yes.
Your lordship is sitting in the writ jurisdiction, your lordship will find in various petitions, sentence starting at page number 3, ending at page number 5. প্রচুর আছে, খুঁজেই পাবে না কোথায় শুরু কোথায় শেষ। But the second one is the disputed question of title. Based on the 5 indentures.
Question of title.
Based on the 5 indentures.
Based on the indentures produced.
The indentures produced.
Produced by KPT. By petitioner.
Are not adjudicated in the writ jurisdiction.
We're taking note. Take note seriously.
Milord, only one more judgment period on this point. This is 2024. 2024, volume 6. Supreme Court cases.
Yes.
Page 579.
Paragraph.
Where para 22 onwards.
All right.
Present Chief Justice.
একটা হলুদ ওই যে মার্কার হয় না পেন চওড়া গোটা দুই আনান না ইয়েতে একটা আলমারিতে রেখে দিন একটা আমার দিন আনাবেন কালকে আনান yes
para 22 the law with regard to entertaining a petition under article 226 in case of availability of alternative remedies well settled. In Shottavati tender, this court observed the same quotations. Then para 23. It could thus be seen that this court has clearly held that the High Court will ordinarily not entertain a petition under Article 226 if an effective remedy is available to the aggrieved person. It has been held that this rule applies with greater rigor in matters involving recovery of tax, cess, fees, or other types of public money, etc. Then the court clearly observed that while dealing with petitions involving challenge to action for recovery of public dues, etc., the High Court must keep in mind that legislations enacted by the Parliament and state legislature for recovery of dues are a code unto themselves, inasmuch as they do not only contain comprehensive procedure for recovery of dues, but also envisage constitution of quasi-judicial bodies for redressal of grievance of any aggrieved person. It has been held that though the powers of High Court under Article 226 are of widest amplitude.
Which paragraph? Which paragraph?
Milord, I am at Placida B at page 586.
Amplitude. Yes, yes.
It has been held that though powers of the High Court under Article 226 are of widest amplitude, still the courts cannot be oblivious of the rules of self-imposed restraint evolved by this court. The court further held that though the rule of exhaustion of alternative remedy is a rule of discretion and not one of compulsion, still it is difficult to fathom any reason why High Court should entertain a writ petition filed under Article 226. The view taken by this court has been followed in Agarwal, then in State Bank of Travancore, the same para 26, Vishwabharati, para 27, then para 28.
Para
28.
Yes.
It could thus be seen that this court has strongly deprecated the practice of entertaining writ petitions in such matters. Recently in so-and-so, then kindly take para 30. It can thus be seen that it is more than a settled legal position of law that in such matters the High Court should not entertain a writ petition under Article 226 of the Constitution, particularly when alternative remedy is available. Then, Miller, in the facts of that case, and finally, Miller, please take para 38, last page.
Yes.
It has, however, been clarified that the High Court will not entertain a petition under Article 226 if an effective alternative remedy is available to the aggrieved person or the statute under which the action complained of has been taken itself contains a mechanism for redressal of the grievance. Undisputedly, the case doesn't fall under exception. We are therefore of the considered view that the High Court has grossly erred in entertaining and allowing the petition under Article 226. 38 says will not entertain.
Yes.
This is. These are the two judgments.
Yes, sir.
Mr. Mukherjee had cited Miller 1998 volume 8 Supreme Court cases page 1, where this judgment has been considered in the first judgment that I have shown, 2022 volume 17 Supreme Court cases 332. Mr. Mukherjee's judgment has been considered over there.
So you distinguish then, will you?
No, not required because 1998 volume 8 Whirlpool is.
Oh, Whirlpool.
Yes. One of the first judgments which we often cite.
And that has attained the status of locus classicus.
Yes. Therefore, but Miller, Supreme Court says that Whirlpool principles still apply. No dispute on that. Question is whether despite alternative remedy being available, whether the court should entertain them. And this is a case where, as I, in my very humble way, Miller, pointed out these 2 points. This is a case, Miller, which can be better adjudicated or even agitated before the. Yes, these are the points where which has been raised in this proceeding. In my very respectful submission, can be better canvassed and adjudicated.
Repressed or considered, whatever you say, before the appellate authority.
And thereafter, the remedy under 226 is there. It's not that they are remediless. Yes. Yeah? Yes, they may succeed also over there. Miller, these are Miller on the entertainability of the writ petition without saying that it is not maintainable.
So the legal argument on entertainability you have done.
Right.
Completed.
Yes.
Facts you have already covered to come to that argument.
Yes. Yes.
So now what else? Next stage.
Now is, but kindly permit me to come back on another day, but I'll indicate my points. First is whether at all jurisdictional facts are required to be stated or not. In my very respectful submission, no. Statute does not provide.
Argue on.
But I would like to come back on.
Interesting point.
Yes. I like to come back on another day. Again, without. King. ও ভালো ছেলে ও ভালো ছেলে
ওই জন্যই হাওয়া হয়ে যাবে
But I can come back on the Thursday. I mean, day after tomorrow. If your lordship's business.
কি আছে দেখুন তো.
Yes, I can come back on 31st.
But when will you file your note? Because after you complete, you have nothing to do.
Look at him.
They will reply to your submission. So they will take time after they reply, but you can file your note. Thursday? Kichu fix nahi. ঠিক তো? আমার কিন্তু বেইজ্জত হতে নয় এজি সাহেবের সামনে।
Let it retain its position. It's number 1 today.
আসুন। What's your name?
Abhishek Banerjee. Abhishek Banerjee.
Mr. Abhishek Banerjee, learned advocate, appears for the petitioner. Mr. Kishore Datta, learned Advocate General for the state, with Mr. Shamrat Sen, learned Assistant Additional Advocate General, appears for the respondents. All.
No, KMC.
Respondent, state respondent. You're for the state respondents, Mr. Datta?
I need one clarification. I think Mr. Kaur is also appearing for some.
Yes, he appeared for somebody. I do not know for whom. এটা দেখিয়ে দিন না।
Joydeep Kaur for Judicial Department. Judicial Department কি নাম্বারটি? ঠিক আছে।
আচ্ছা, you are for one. So Shamrat Sen appearing for respondent number 1.
এই শিশান্ন নামটাও দিয়ে দাও। But Shishanu Bandyopadhyay is also with us.
He is in court because yesterday I was told he is
No,
outside.
yesterday he was outside, today is in court.
With Mr. কি বললাম পড়ুন।
আর এখন তো ইনসাইড আউটসাইড
কিশোর দত্ত, সম্রাট সেন and Shishanu Bandyopadhyay, learned Senior Standing Counsel, appears for respondent number 1.
Only one.
Paragraph. Yes, sir. Mr. Ghosh, you are for? Respondent numbers? Mr. Alok Kumar Ghosh with Mr. Achinto Banerjee. অত নাম এখানে। Learned advocate appears for respondent numbers. Only. 4PO26 ব্র্যাকেটে KMC ভাই স্ট্রোক দিয়ে করে দাও, স্ট্রোক দিয়ে KMC এই নম্বর। Mr. Datta, none appears for others today.
আর কি আছে? আর তো কেউ নেই। জয়দীপ দাস সাথে জুনিয়র কে আছে? Oh, Mr. Mondal is there.
Okay. Full name?
With Arindam Mondal.
Mr. Arindam Mondal, learned advocate, appears for respondent numbers?
2 and 3.
2 and 3. Stroke. Key department বললো?
Judicial Department.
Stroke. Judicial Department. Paragraph. Learned Advocate General has been continuing with his submissions. Full stop. Today, he has concluded his submissions on the point of entertainability of this writ petition in view of the available statutory appellate remedy. Full stop. On the next day, he shall continue with his further submissions on the merit. Full stop. Paragraph. The writ petition shall appear under the heading কিভাবে আছে? Court application under Article 226 bracket is specially assigned, marked at 2 p.m. on
Day after tomorrow, 31st.
July 31, 2025. Thank you.
I'm grateful.
Thank you. What happened to that? Any result?
So we have mentioned, not some of it. Maybe next week we have
three more miscellaneously before the matter is returnable before this court. This Friday and Monday and Friday of
No.
this week.
I have only interest for the academic reason.
Exactly.
Absolutely for academic reason.
But in this hierarchy, orders are all orders are susceptible to be taken up.
Absolutely. Why not? If somebody has a remedy, why not? I am only interested for academic purpose. That's all. That's all. Thank you, sir.
Apply for the petition in this matter, my lord. This is my report in a form of, my lord, reply to the exception to the report, my lord.
What is the matter?
Matter, my lord, the same matter, my lord, Maya Bauri. Same
It has been filed in the department. I am not aware whether it is on the
Take
record
the
or not.
microphone. Take the microphone. Mr. Ghosh, set the microphone for him.
My lord, report has been filed with the department.
Report.
Report on
filed
behalf
by
of
you.
the. It is on the record.
Yes. Report. So your report.
Yes, our
His report, my lord,
respondent's report.
he, my lord, possibly, my lord, he, my lord, by mistake, my lord, filed the report in department. It has, my lord, reached to your lordship's court, my lord.
It has been filed in the
But this is a
department.
case of in 1996, my lord, husband died. And thereafter, my lord, the application was made. In 2002, they rejected the employment. Now, my lord, at this stage, my lord, 58 years age. So I'm asking the monetary compensation, my lord.
My lord, in short, I will make some few points. The employee died in the year 1996. It is not on record. In the writ petition, it has not been disclosed when the widow applied. But in 2002, the ECL informed the petitioner that claim for employment for her son was rejected due to medical unfitness of the person. This was the ground. Now
he is not claiming for appointment now.
No, my lord,
He is-
my lord.
He is
Only
only
one
claiming
point
NMCC.
I want to bring your lordship kind notice on facts that from 2002 up to till 2023, petitioner was totally silent. Now management say at least a reasonable time after 2002, 23, she applied after long time, more than 20 years. Thereafter, she has come for this benefit. This is I have already all things I recorded in my submission. So taking into consideration of all the facts that they were totally silent, and if
page 31, if you can come.
When the management rejected the claim of the petitioner's son, she could have claimed for compensation at that time. From that date, we would have given. Now management wants that a reasonable time. Management has taken a policy that who will not submit the claim within the time frame, their claim can forgo. So it is implied that there is no hardship to maintain themselves.
Give me that policy. Show me that policy.
It is an internal circular. It was circulated.
No value.
We have not
Sir,
disclosed.
Your pension scheme.
Not
and
pension.
No. Your pension scheme and the coal agreement. That has achieved by this time a statutory flavor.
Right.
After being considered up to Supreme Court. Right? Then the larger bench is there, following which Maya Bauri. Right. Question is, these are all benevolent legislation. And the larger bench has already decided, following which I have also held in Maya Bauri, It is the responsibility of the employer, even if no application is there. Even if no application
My
is
lord,
there.
I beg to submit the
What I
point,
can, what I
point
can,
for substantial delay on the part of the claimant petitioner, that has not been decided even by apex court still now. That point has not come. That is why management is going to file appeal further. Mayabadi also.
you can amend your I mean, the
Ma-
whole agreement.
My lord, agreement does not cover this aspect. Nothing. It is silent.
Absolutely. The moment it is silent for a welfare act, then it has to be liberally construed.
Right.
If your management amend that agreement in accordance with law, the way it will be done, the way it will be required to be done in the eye of law, since it's a tripartite agreement, bipartite, and introduce this provision in the agreement, matter ends, that will prevail. But so long that is not there, very difficult. I will record your submission.
My lord, management is going to file appeal against Mayabadi and all the cases to fix up that principles. That is my humble submission. So relevant facts may kindly be submission.
I will.
Yes.
I will definitely deal with it here and now.
Because object of the scheme is getting frustrated.
I will.
Due to this long delay.
Page
And in this case particularly, friend, 2002, when the petitioner was informed that due to medical unfitness, claim has been rejected, and only 2023, she applied for compassionate appointment.
Page 31, if you are
I am not.
Not appointment, for compensation.
Compensation.
Yeah.
I will not.
Not for appointment.
I will not give appointment. I will not allow any interest. I will not give appointment. I will not allow any interest. That's for sure. That's for sure.
Page 31, if you are kindly come.
Only thing I will have to consider in such an inordinate delay.
My lord, management only.
That's why I am praying, kindly see page 31.
In such an inordinate delay, whether I will direct from the date of application or date of death.
Page 31, if you are kindly see.
31, yes.
This is a document of 2011. My learned friend is saying that it
One
was,
second, you are directed to see the undersigned.
again they have,
Any working day along with such and such.
they are considering my prayer.
My lord, this document.
What steps you have taken, sir? 2021 till 24. Show me.
Yes, thereafter, my lord, I have filed this, my lord, application page 32 in 2011. Then, my lord, fitness certificate, format, etc. They, my lord, intentionally, my lord,
Sir,
my lord, this document we have not admitted.
No, they have asked for the document. I have submitted.
We have regretted medical fitness. My lord, my lord, provision is.
Wait, let me understand. Yes.
Page 31. Well, if you also kindly see page 22 first. Page
31.
Page 29. My learned friend is not, my lord, stating the entire fact. The competent authority has considered your claim in place of your deceased father ex-employee, as you have been declared unfit for duty by the initial medical examination held or such and such. So my employment has been rejected 2022. 2002. Again, my lord, I was pursuing, my lord, I was representing my case for, my lord, compassionate employment in favor of my son. Now, 2011, what they have written, page 31, you are directed to see the undersigned on any working day along with original documents of outside specialist, if any, in favor of your claim. This is as per letter number such and such of 2010. Then, my lord, page 32, outside medical, they have sought for
11.
Immediately. Here with a copy of the medical certificate issued by the Sub-Divisional Hospital Asansol regarding my eyesight fitness as desired White letter above. I have already clarified that I have no any eyesight problem. I am a sportsman and quite fit to do any job.
Very well.
Sorry,
Next.
sir. Thereafter, I have deposited all these documents, page 33, 34.
17. After 6 years.
No, that is
Yes. After 6 years.
6 years, but before
2017.
that, I have also, because it is.
Up to page 32, I take it. Yes.
No, 32 I have deposited.
Right.
Again, my lord, in 2017 I have deposited.
Right. So in between 11 to 17, no step taken.
No.
Then 17, thereafter.
Thereafter, my lord, page 17, page 33, 34. Thereafter, application in
These
2000.
are all of 16.
Then 2000.
16, 17.
Then
nothing, 23.
23.
I will have to consider this. Mr.
After
Ghosh.
2011, we have not
My
made
lord.
any correspondence.
One thing. You file I'm recording your submission.
My
I'm
lord.
not
My lord.
dismissing the writ petition.
My lord.
You file a detailed affidavit in opposition.
They have filed, my lord.
A report I will not take.
Well,
in this type of matter.
Interground has been taken.
Very well. I will ask them to file an affidavit in opposition.
Well, all ground
Because
has been.
it is equally true. It cannot be an open-ended provision.
We will be highly grateful. We will
That
be
is,
highly
that is
grateful.
already there.
If,
So we will consider.
yes.
It is already settled by this honorable court.
I will
Even up to
consider.
Supreme Court, even delay
My
point
lord,
they have
the
considered
demand
up to
facts-
Supreme Court.
I will consider.
My lord, next day, kindly, my lord,
No
for
after
the
affidavit.
but for that matter, my lord, already they have filed. You kindly see what is their ground, what
All
more
right.
they will develop.
Ashu.
And in the meantime, my lord, let them start my MMCC from the
The moment they will start, then the moment your claim will be accepted and you will say, why
no,
not?
in my view of the court's order,
What court order?
your lordships direct them, my lord, to pay the MMCC from the date of application when my son and made an application for employment. Let them start at this because I am entitled for the MMCC.
You will be entitled for MMCC. But which date?
From the date of application,
What date of application, sir?
at least from 2002, because they have rejected my claim in 2002.
2002,
Yes.
when the employee died.
No,
96.
employee died 96.
Yes.
They have rejected, my lord.
You have pursued your claim till 2023.
So they have, this is that, then this is their fault.
That I will, yes, that I will.
Page 29, if you
I will
lordship kindly
decide
see.
on affidavit. Ashu. Because this open-ended thing cannot be done.
My lord, kindly, my lord, make it not today. I will satisfy your lordship next day.
You-
Because there is.
I want an affidavit from them, detailed affidavit.
Affidavit.
Then you will argue.
My lord,
I will
my lord,
absolutely
my
hear
lord,
you.
kindly see their affidavit. For a moment, kindly see, my lord, because it will.
Sir, this is a report.
Kindly see what ground they have taken.
Let them
Delay
come up.
point they already
Beg
been
to
taken.
submit
Let
everything.
them come up with affidavit
Yes,
in
yes.
opposition, one such matter, because this open-ended cannot be done.
But
It's
that
a
has-
public money, public exchequer. at
That
the
has
end of the
already
day.
been, my lord, held by the special bench in
That's
Pudul
fine.
Ravidas.
That's, sir, I also followed it. I said that.
And that is also the
I
case
will
of
have to-
1996.
Yes, I will have to read that judgment once again. That whether, how much delay was there.
Yes.
1996.
1996, then what happened? The larger bench, I don't know.
Yes, that's why, my lord, I am praying, my lord, kindly make it not today, my lord, I will satisfy your lordship next day.
Let them come up with an affidavit. Let them find.
In that, even, my lord, kindly some interim order may be passed because this lady will, my lord, starve.
If you could wait till 6 years, 7 years, no issues, no interim order. Ashu.
And delay point has already been decided by your lordship's order, my lord.
Sir, I will have to look at them, how much of delay it was decided.
My lord, kindly see, my lord.
2 years, 3 years, 5 years, and 25 years.
Last order, kindly see, my lord.
Ashu.
Last order, kindly see.
Yes, I will decide.
96.
I will decide it again, if necessary. This public exchequer fund cannot be kept for open-ended. After 20 years, somebody will come and lodge its claim.
But this is continuing, my lord, cause of action.
No continuing cause of action.
Yes.
You have to pursue your right.
No,
So let
it's
me
not
see that.
required at all, my lord.
Right? We will see.
Because this is welfare officer is there. Their officer is there to look after all this issue. Once they reject it, it's their duty, my lord, to process the entire claim.
All right, let's see. Let the affidavit come. কি বললাম? Mr. Partho Ghosh, learned advocate, appears for the petitioner. Mr. Your name, sir?
Anupkanti Poddar.
Anupkanti Poddar, learned counsel, appears for
Uh,
ECL.
1 to 3 respondent. 1 to
ECL.
3.
ECL.
Hey, 1 to 3 কেন সবগুলোই তো হবে বাকিগুলো কে অ্যাপিয়ার করবে তাহলে অল আর ইসিএল my lord, not only 1 to 3
রিপোর্টটা ফাইল করেছি
up to
1 to 3.
up to 6 my lord.
How petitioner is related with the employee, sir?
How petitioner?
Husband was my employee, my lord.
Sumitra?
Husband, wife of the deceased.
Wife of the employee.
Mongola Bauri. Mangalabauri. It is bold. Since deceased was an employee of ECL.
My lord, on behalf of all respondents.
Mongola died on
18 November 1996.
November
18
1996.
1996.
এই ডেট গুলো সব বোল্ড হবে। Who was Danao? Panna Baudi? Come to page 29.
Panna Baudi's son.
After the demise of Mongola, his son Panna Baudi applied for compassionate employment. Under the
Eastern Coal Limited.
No. কি বলে ওটাকে wage agreement of that?
National Coal Wage Agreement.
Under the National Coal Wage Agreement. Full stop. By a communication dated July 25, 2022, Annexure P2 at page 29 to the writ petition, the claim for compassionate employment was rejected. The rejection communication shows that the application was made by Panna on July 24, 2002. Further, on March 24, 2010.
But this date is for my lord, their internal communication date, 24 July.
No.
Yes, my lord.
This is pursuant to the letter number such and such. Oh, of personal. Sorry, thank you.
1996, I applied. They, my lord, pursued the my lord issue.
But there is no record of application in 1996.
All right. Please listen what I am.
Yes.
If there is any factual mistake, correct.
My lord.
You will know. ওটা কেটে দাও রিজেকশন কমিউনিকেশন শোস কেটে দাও compassionate employment was rejected.
On the background of medical
Further, Panna applied for compassionate employment which was also rejected by a communication dated November 7, 2011. Annexure P4 at page 31 to the writ petition. On the medical ground. First, by a communication dated September 19, 2011, Annexure P5 at page 32 to the writ petition. এইসব ডেটগুলো কিন্তু বোল্ড। Panna applied before the coal company, relevant coal company, for reconsideration, for re-examination by the medical board. A medical certificate dated January 4, 2017, Annexure P6 at page 33 to the writ petition, issued by the medical officer, Asansol District Hospital, shows that Panna was clinically fit then. Thereafter, a long silence, and ultimately on July 12, 2023, Annexure P7 at page 35 to the writ petition, the writ petitioner, being the widow of the deceased employee, applied for monetary compensation with interest under the said coal wage agreement. Bracket MMCC or what? MMCC. Bracket MMCC. Full stop. Paragraph. Mr. Partho Ghosh, learned counsel for the petitioner, submits that at present the petitioner prays for monetary compensation.
Alternative prayer is also there, either employment to son or, my lord, the monetary compensation to
or in the alternative, an employment to Panna. First. কি বললাম পড়ুন? Or না, or হয় না, in the alternative. And filed the instant writ petition on or about October 3, 2024. Paragraph. Mr. Partho Ghosh submits that the provisions under the coal wage agreement has been tested and travelled up to the Honorable Supreme Court and have been upheld. A larger bench of this court has also considered the provisions and upheld. Following the larger bench, this court has also delivered its judgment. First up. Therefore, there is no impediment in allowing this writ petition. At least directing to pay the monetary compensation. Paragraph. At this juncture, Mr. Anup Kante Poddar, learned advocate appearing for ECL, submits that the facts in the instant case would show that since the first rejection for compassionate employment in the year 2002, the petitioner did not pursue her right for compensation until July 12, 2023, at page 35 to the writ petition. Long 21 years have elapsed. He submits that due to this inordinate and unexplained delay, no relief can be granted to the petitioner. This is your submission?
Yes, ma'am.
After considering the rival contentions of the parties, submission, he further submits that the coal wage agreement cannot be an open-ended provisions, that even after an inordinate, unexplained delay, monetary compensation can be granted, shall be granted. First paragraph. After considering the rival contentions of the parties, though it appears from record that the ECL has already filed a report on affidavit, and dealing with the same, an exception on affidavit has already been filed. By Mr. Ghosh, by the petitioner, still, in view of the submissions made on behalf of ECL recorded above, the respondents shall file an affidavit in opposition on or before August 14, 2025, affidavit in reply, if any thereto, shall be filed by August 21, 2025. The writ petition shall appear under the heading, court application, original site to, under the heading for orders. On August 26, 2025. Full stop. It is made clear that no further extension shall be granted to ECL, to the respondents, if they don't file affidavit in opposition as directed above. Full stop. In the event no affidavit in opposition is filed, the court shall proceed on the basis of the report on affidavit, which is already on record.
But my exception be kept with the record. No.
Exception in the form of affidavit filed on behalf of the petitioner is taken on record.
Well, only one thing, well, there are a lot of documents lying with the file, but petitioners do not have that documents. Kindly direct them to disclose all documents lying with the file. Because I made an application in 1996. Kindly visualize this. They are the poor illiterate, my lord, scheduled caste, scheduled tribe lady. So immediately they have filed the application in 1996. They are not disclosing the everything.
The respondents shall also produce the original file relating to this petitioner
My lord.
at the time of hearing of the writ petition.
My lord. Grateful to us. Grateful.
Ultimately, I may hold in favor of the petitioner, but equally it is also true that this open-ended.
Your lordship is absolutely correct, but this point, time and again, they have argued.
How long, Mr.
In all
Ghosh?
cases, facts are not same.
How long, Mr. Ghosh? Rejection, death, very well. Within 2 years, application filed. Fair enough. Rejected. Fair enough. 2 years, 3 years, 5 years, at a reasonable time. After 25 years, people will lodge their claim just because public exchequer.
The continuing cause of action is like a pension.
Continuing cause of action, if you have to, then also you have to pursue your right. Simply apply the principle of limitation. I'm not saying rigorous application or 3 years limitation, no. But why the law of limitation? To stop the proceeding for a litigant who has not pursued his life. Right. Pursued his right.
This part has already been decided. 3 years limitation, my lord.
I am not absolutely on 3 years. Absolutely, more than 3 years. I don't mind for that. But that does not mean 23 years. There the question of equity will also
And
come.
all the judgments relating to this issue, all the judgments are.
You bring all those?
No, I have ready copies. I have
The part has not been dealt with.
You bring all those judgments so that, as I said, I might hold in favor of the petitioner. But let my conscience be clear.
Yes. Very well.
Let my conscience be clear.
Very well.
So public exchequer, open-ended. Whenever somebody will come and claim, he will take the money.
Very well. No problem.
Grateful,
changed. Benevolent, yes. But how long? How long? 24, 5 years. Nobody has pursued his right. Suddenly, after 25 years.
I will satisfy the lawyers.
Of course. I will hear you. It will be a pleasure to hear all of you. Thank you.
Grateful, man.
You ask your client to file affidavit within time. Otherwise,
Yes,
I will
within
not
the
try.
time will.
And you come in. Acha, ekhane likhe din to. That an advocate on record for the petitioner shall communicate this order to the respondents forthwith to enable them to produce the record on the next day. You also communicate. Bring the Mr. Poddar, you communicate
Yes,
and
yes.
bring the record
Yes.
on the next day.
Yes.
Yes.
My lord, I am appearing on behalf of the respondent number 229.
For only not today, my lord. On behalf of Govinda Gaur.
That's true.
My lord, the report be taken into consideration, my lord. On the last occasion of 8th of this month, my lord, your lordship has directed for a joint inventory. What has happened? The petitioner has been superannuated on 30th
this is
June
my
2019, my lord.
This is my writ application.
Your exception?
No, this is my report, your lordship detected. That copy also I have not, my lord, seen. Your lordship detected both of us to file report. In respect of the report,
Both of you?
yes, in respect of the inventory, in relation to, my lord, the eviction, my lord, for vacating of the quarter. Now, my lord, I have also prepared report. Disclosing, they have not, they have refused. I will satisfy your lordship. Kindly allow me to
Well,
place
the
my
page
case.
number 20 can be taken of my.
Right, all right. আসুন একটা একটা করে হোক আসুন pursuant to the order dated July 8, 2025, both petitioner and the relevant coal company filed report today in the form of affidavit. Full stop. The reports are taken on record. Yes, Mr. Ghosh.
Here, my lord.
Let us read the order. It records everything. Read the order.
Last day's order. Mr. Ghosh, learned counsel appears for the petitioner. Mr. Agarwal, learned advocate, appears for the ECL. The petitioner is a retired employee of East Relevant Coal Company, retired on 11th June 2019. The petitioner claims part of the retirement dues which has not been has yet been released on account of the earned leave, such and such, such and such. Learned counsel for the appeal ECL submit that after the retirement, the petitioner has not vacated his quarter, which was an accommodation of the coal company provided to the petitioner. Thus, the all full retirement benefits had not been released. The learned counsel for the petitioner submits that the petitioner has offered the quarter to the employer coal company to take back the possessions immediately on retirement, but the employer coal company refused to accept the possession.
Great. Come on.
Now, my
Let me read both the reports. Show me the joint inventory report. My specific direction to.
My lord, my page number 20, my lord. Ours report, my lord.
All right, let me read the petitioners first. Page
10.
Report. Read it.
On dated 5th July 2025, at about such and such quarter of Krishnakanto Chaudhary, jointly inspections has been done in presence of Sri such and such, such and such, such and such. My relevant portion I am reading, my lord. Now, my lord, the inventory report are as follows. The quarter is C-type quarter with 1 hall, 2 bedroom, 1 dining area, 1 western side toilet, 1 Indian toilet, courtyard in backside. The quarter is in very dirty condition. The quarter was having lock, which is under possessions of Krishna Bandhavadhyay.
Quarter was having
locked.
Achha.
Under the possessions of Sri Krishna Bandhavadhyay. There were 5 bulbs.
Krishna Bandhavadhyay is the petitioner.
Petitioner. There was 5 bulb, 1 ceiling fan, such and such, such and such. Thereafter, my lord, the quarter has been locked by Sri Krishna Bandhavadhyay and thereafter in the possessions of the Krishna Bandhavadhyay. Now, this is the inventory report. This is the inventory report.
Where is the signature of Krishna?
At bottom. At bottom. At first, my lord, the officers,
Krishna.
officers of the ECL, one the representative of the ECL, and then at bottom, my lord, Krishna.
Krishna Bandhavadhyay, ex-manager.
Ex-manager.
Mining.
Now, if your lordships kindly come, my representation at page 22 of the writ application.
Tell me.
Here, my lord, from the day 1, I am offering the possession and, my lord, handing over the quarter. They are constantly, my lord, refusing. Even then, in spite of your lordship's order, they have not taken possession of the quarter. This is the fact in reality. Now, they have charged the penal rent. During pendency of the writ application, I have also annexed those documents as well in my supplementary affidavit. They have charged penal rent for the period from the date of retirement, not date of retirement, 3 months after the date of retirement till date. Now, kindly come page 22.
Yes.
Sri Krishna Bandyopadhyay, ex-man such and such. I have vacated my C-type quarter located beside Sonpur Bazari area office on 1st 11/2024 and have given a written information to the administrative officer of Kendra area to take handover my quarter by hand, but till date no action have been taken from your end. You are once again requested to take charge of the vacated quarter and issue me a
Mr.
letter.
Ghosh,
My lord.
simple question.
My lord.
Do you deny the factum and validity of this minute?
No,
That it
no.
is not yet vacated.
Not because they are, my lord, I have handed over. Well, kindly see, I have vacated. I am not using that quarter. But unless and until they take, my lord, the keys from me, then quarter will be, my lord, the doors, pakha fan, etc. everything. I have already deployed 2 persons. I have also disclosed there, my lord, in my affidavit.
So better go to civil court, both of you fight it out there.
No, I am agreeable to vacate. Unless they take possession, what can I do, my lord?
So show me the contemporaneous document when you offered possession and thereafter what communication.
Page 22. Page 22.
From your writ petition.
Yes.
Page 22.
This is the second reminder.
This is the
Second reminder. Second letter, my lord.
Please photograph.
22 of the, my lord, writ application, my lord.
Achha. (22) is the
letter communicated by the petitioner to the area personnel manager of Eastern Coalfield Limited.
22.
At bottom, kindly see. You are once again requested to take charge of the vacated quarter.
When you retired?
2019.
19.
Yes.
Very well. 19 to 2nd December 2024, you pay the penal charges first.
No, 2000, not 2000, till it would be October.
Very well, whenever.
They have computed. I'm coming to that point.
Whenever, no.
First,
let me test your bona fide. You are the writ petitioner.
No.
Let me test
No,
your bona fide.
money is lying with them. They can deduct. That is not the issue. They can deduct. But I am coming to that whether they can at all deduct or not.
Oh yes, of course they can.
I am coming to that, my lord. Then my lord,
Let go and before the civil court. I will pass my order dismissing the writ petition. I will send it before the civil court. They will immediately go for eviction proceeding, and whatever benefit is lying with them will abide by the decree of the civil suit.
But civil court has no jurisdiction.
Of course, civil court.
Civil court has no jurisdiction.
Whatever, public premises unauthorized eviction.
Now, yes. Now kindly see section 3B of the PP Act.
Sir, wherever they will initiate proceeding tomorrow.
When they have initiated the proceedings, they have not initiated proceedings.
Mr. Ghosh, let me be very candid. The petitioner is playing with the court.
No, certainly not. Certainly not.
Very well.
Certainly not. Petitioner is always agreeable to vacate.
I am dismissing this writ petition.
My lord, they are not accepting. Kindly record my submission. Last day also I have submitted. They are not taking the keys in 2024.
My lord, can you come to page number 10, my lord, of my report, my lord. The security officer on 10th of December 2024 has visited the place and has found out it was under the possession, my lord. And secondly, my lord, if I go into the writ petition, page number 10, my lord, the security officer report is there, my lord. And even if I take into consideration, my lord, the writ petition avertment number, paragraph number 9, page number 7, what the petitioner has said. The petitioner says that ultimately he vacated the official quarter on 1st of November 2024.
Yes.
He says out in this way, my lord. But what has happened? We have an SOP, my lord. When a person gets retired, he makes an application. Thereafter, what happens, my lord? The security officer goes and takes out and makes out no due certificate on the application. Thereafter, the civil department goes and see what the condition of the
Answer my question. Is it true that you have not taken possession of the last
No, my lord.
No.
Page number 10.
Last inventory.
No.
Pursuant to my direction.
No, he did not.
No.
Can I see the photographs, my lord?
Well, only they have said since
you have not taken possession.
My lord, if they give out the flat, if they give the flats keys with us, if things are given, even the civil people has gone, Even the finance
So
people
what
have
did they
gone.
do? What did they do?
He has taken his belonging on that day. On 15, there were a lot of belonging. I can show the photographs.
What did they do?
They standed there, made the inspection. He opened the key when everybody was standing outside. He opened the key. Everybody got entered. Thereafter, he collected his belongings, Mr. Krishna Bandopadhyay. Thereafter, they asked out for the keys. He refused. So thereafter, he came and put down the keys and took the keys along.
Where is the my lord,
So
statement?
at your instance, at your payment, I am appointing a special officer who will go
No,
take possession.
I am ready to hand over. I am ready to hand over the key at any day. Any day, I am ready because I am retired. Kindly visualize the situation, my lord. On that day, what they have said, kindly read the order of the court. Court had not said to hand over the key. Court had said inventory, so you confine to the court order. That was their version. I am ready to hand over any day.
Very well. I am simply adjourning. Hand it over tomorrow.
Yes.
Hand it over tomorrow.
To whom, my lord, kindly, my lord, record. I record the order. Otherwise, they will not accept.
Very well.
In 2024, my lord, kindly see.
I do forget. I was also there.
No, my lord. The petitioner was there. Just now he left for the train, my lord. He was there. I asked him to come, my lord. And my lord, I have personally inquired, my lord, whether because your lordships may know.
Both the report contains a joint inventory report. Joint inventory report, which is at page 20 of the affidavit of report filed by the coal company. The factum and validity of the report, the existence of the said report is not denied by the parties. Full stop. The report speaks for itself. Full stop.
Inventory report, my lord. Report means, my lord, inventory, can I mention in?
Inventory, I say.
Yes, my lord.
Full stop. কি বললাম? আস্তে আস্তে বাবা, তুমি না বুঝতে পারলে আমায় থামিয়ে দাও। তুমি কি নতুন? সব বাস করেছে। তুমি আমায় থামিয়ে দাও, হ্যাঁ, থামিয়ে দিয়ে ঠিক করে লেখো। হ্যাঁ, বলো কিভাবে শুরু করেছি। প্রথম থেকে পড়ো, চেঁচিয়ে পড়ো। হ্যাভ ফাইলড করে দাও। ভালোই তো লিখছো, পড়ো। both the হয় না, both the reports contain in present tense. Affidavit of report now, which is at page 20 to the report on affidavit filed by the coal company. Is not denied. সব বাস দুটোর মানে পুরো পাল্টে যাবে। Is not denied. Speaks for itself. Full stop. The report shows that possession has not been delivered by the petitioner and or not taken by the coal company. Full stop. Comma, as it is submitted by the rival parties. Paragraph. Be that as it may, to proceed before proceeding any further with this writ petition, Mr. Partho Ghosh, learned advocate, comma, on instruction, advocate for the petitioner, on instruction from his client, undertakes to hand over the keys and thereby deliver possession of the subject premises in favor of respondent number.
The respondent number. Yeah, just. The respondent number 7, Mala.
Respondent number 7 positively by 12 noon on July 31, 2025. Paragraph. Upon possession being of the premises being delivered by the petitioner and the same being taken over by the ECL oblique respondent number 7, a joint minute shall be drawn up by and between the parties, which shall be signed by the respondent number 7 and the petitioner. Full stop. The parties shall then file their respective reports by way of affidavits, annexing the said joint minute showing delivery of possession of the premises before this court on when the matter shall be taken up next. The writ petition shall appear under the heading court application on August 5, 2025.
Well, only one thing, my lord. On my lord 31st, kindly direct my lord respondent number 7 be present on spot because they are, my lord, security personnel are going.
Sir, unless they present, how they will?
Last order was also there, but they are.
It is needless to mention that both the petitioner and the respondent number 7 shall be personally present, and then the possession shall be delivered to respondent number 7.
Well.
And the joint minute shall be drawn up as directed above.
Well.